But specify fresh admission orders to notice order.
Recording in progress.
Kindly write, sir. Orders में लिखी दियो for order. Yes.
Supplemental list, page 1, 2, 6.
My lord, item number 5. I am praying on behalf of Mr. Tripathi, my lord. This honorable
Mr.
court has directed for
Mr. On behalf of Sushanta Kumar Tripathi, adjournment is sought for at the beginning of the day's proceedings.
affidavit is to be filed.
He submitted that at the beginning of the day's proceedings, adjournment is sought for on behalf of the Honorable Counsel for the petitioner. At the beginning of the day's proceeding, he submitted that as observed by order dated 1/5/2026, the affidavit is yet to be filed on behalf of the petitioner. Stop to grant further opportunity. The matter shall be listed for fresh admission in the week commencing. 3/8/2026.
Oblast.
Pardon to mention, my lord. Item number 4, my lord. I am appearing on behalf of some S. Mahadi, my lord.
Your name, sir?
Dilip Kumar Sahu, my lord.
So Dilip Kumar Sahu on behalf of Mr. Samarendra Mohan.
Due to illness of my senior, my lord.
Judgment sought for on behalf of the Learned Counsel for the petitioner. Illness has happened after the order dated 22/1.
No.
So that has no apparent treatment. Court order of 22nd January has no apparent treatment.
No, my
At
lord.
times you find that nothing works or no kind of highest kind of antibiotics do not work. If the petitioner is fine, then you should file the affidavit.
No, my lord. No, only lord and senior.
Because your Lord Senior cannot help. It is for the petition, it is petitioner's case, it is not your case. Even your Lord Senior's case. Only. From 21st January 2026, when the matter was taken up, the effort of the petitioner has been to adjourn the matter as it has been on 17/26, 16/4/26, 13/5/26. The points of law as well as the facts, those were noted by order dated 22/1/2026 are yet to be answered by the Learned Counsel. On behalf of the Learned Counsel for the petitioner, on ground of personal difficulty. To grant further opportunity, the matters have been listed for fresh admission in the week commencing 3/8/2026.
Oblast.
Let's same page, item number 3, or let's say. No, his sister's sister's marriage is going to be held tomorrow.
Sorry, January pare tithi nahi. Because June 30 pare.
No.
Who panjire hochi? Mane best mane deki poduchi February.
But tomorrow.
पचारे जो मंडप की कैटरर वाला को जल्दी दियो तो आएगा कहते ओसा बार चाली छी वर्तमान पर्यंत भी काली तो नाही अछि ओके खडियत पर 3 तारिख जाय कोन थिला कहते तापर वी हैव टू वेट टिल फेब्रुअरी नेक्स्ट ए वर्ष मळा मास पडुनी कि
ये लॉर्डशिप में पोस्ट
କିଛି ଅଛି
नहीं आनिबे नहले आपण को पेपर डाउन नहीं डिसेंबर नहले पूरा जो बता इवेंट मैनेजमेंट कैटरिंग मंडप तो गला था लगे गोटे
किछि नथा कि है के भाई अछि कोन तात्र अछि
सेटा दैट्स ए बेटर
मनर मिलो ना सेटा की तिथि की बेला
बर्तन जो डिफिकल्टी इन अरेंजिंग द ब्राइड एंड ग्रुप हैज बीन ओबिएटेड वो जो डिफिकल्टी होतला बर्तन डेट फिक्स होला पर तापर खोजा खोजी करी की तापर वेन्यू तो इंपोर्टेंट मोस्ट इंपोर्टेंट है ना
बता तो नुआ ट्रेंड चल जाएगा कोर्ट मैरिज करी गोटे बॉर्डर रिसेप्शन दे दूछ सब दैट इज अ न्यू ट्रेंड visa and all these things becomes easier in a court marriage also. The court marriage पे तो तिथि दो करने लग्न दो करने
one week after item 3
I went that side actually.
item 3, your lordship, 1 week after any day, your lordship may post it.
You are Mr.
K. Mahanti, my lord.
Power Mr. K. Mahanti, and counsel for the petitioner mentions the matter at the beginning of the day's proceeding. seeking adjournment in absence of the learned counsel for the petitioner. Learned arguing counsel. For an absence of the learned arguing counsel. Stop. Para, since 15/1/2026, the matter has been consistently adjourned as of 17/26, 9/4/26, 12/5/26. Stop. To grant further opportunity, the matter shall be listed for fresh admission in the week commencing
3/8.
3/8/2026.
Page 2, 7 to 12.
Lordship, item 7, on behalf of Mr. Vijay Kumar Agar, I'm praying for an adjournment.
Seven.
My Lordship.
What's your name, madam?
Ananya Mahanti. Ananya Mahanti.
Ananya Mahanti. Mr. Ananya Mahanti on behalf of PK Ragada for the petitioner. The matter is mentioned at the beginning of the day's proceeding, seeking adjournment on behalf of the petitioner in absence of the learned arguing counsel. Since 19/1/2026, the effort of the petitioner has been somehow or the other adjourn the matter as it has been on 19/3/26, 6/4/26, 27/4/26, 13/5/26. The response of the learned counsel, arguing counsel, to the order dated 19/1/2026, wherein the questions of the points of law and the facts noted, the points of law as well as the facts noted is awaited. Stop. To grant further opportunity, the matter shall be listed for fresh admission in the week commencing
3/8.
3/8/2026. Yes, next.
8 to 12.
Your Lordship,
10 to 21.
item 10.
10. Your name, sir?
Your
Again?
name. Daman Kumar Sahoo.
Raman or Daman?
Daman.
Daman. So Daman Kumar Sahoo on behalf of Rajiv Lochon Patnaik for the petitioner.
Your Lordship, my senior is ill, hence this case may taken up after 4 weeks.
Adjournment is sought for on behalf of the learned counsel for the petitioner at the beginning of the day's proceeding on ground of personal difficulty.
And for the opposite party member.
Just one second. Since 16/3/2026, the effort of the learned counsel for the petitioner to adjourn the matter continues as it has been on 8/4/26 and 30/6/26. এখন stay হয়েছি stay কি হচ্ছে
Yes, my lord.
তারপরে লিখিবে to grant further opportunity to the petitioner, the matter shall be listed for fresh admission in the week commencing
3/8.
3/8/2026. Appearance list লিখিবে opposite party Mr. Mohammad Faradis,
An interim order may continue.
the learned counsel for the opposite party. Take out to 125 stay ହେଇଛି ନା କଣ?
My lord.
It will not be still 125 ରେ ଆପଣ stay 50 କରିବେ। ଆପଣ ଯଦି ଦମନ ନାଟା ଆପଣ ଦବଙ୍ଗ ପଢନ୍ତୁ, ଲ ଟିକେ ପଢନ୍ତୁ। It is a subject which is to be read. ଆପଣ 5 year integrated ନା କଣ?
Yes.
So 10th class 12th class ଯେମିତି ଭଲରେ ପଢିଲେ ତାପରେ କ୍ଲାସ ଦେଲେ ଆପଣ ପିଲା ଏଣ୍ଟ୍ରାନ୍ସ ଦେଇକି ପଢିଲେ ସେମିତି ପଢନ୍ତୁ। You should assist the court not passing illegal orders, and this is patently almost 60-70% illegal order what I have dictated. କେତେ ଟଙ୍କା ଡ୍ୟୁ ହେଲାଣି ମିଷ୍ଟର ଫାରାଦିସ୍?
My lord, there is no interim order. But two of the
ଆଡଜର୍ନମେଣ୍ଟ
witnesses,
ଟା ପାଇଁ ଏଟା TRPC error 22.
22. Two of the witnesses were examined and cross-examined at length.
Interim order କିଛି ହେଇନି maintenance.
No, my lords.
Unlike the learned counsel for the opposite expresses concern regarding further pendency of the present application as the maintenance proceeding, that is CRP number 122 of 2025, has been interdicted during pendency of the present application. But Accordingly, it is directed that the Learned Judge Family Court Dhenkanal shall proceed with the CRP number 122 of the 2025 in accordance with law. Stop. Copy of this order shall be forwarded to the Learned Judge Family Court Dhenkanal by the registry. Stop. The matter to grant further opportunity litigation, litigation.
मुख्यमंत्री 3 है
Adhesion, 3 Act.
page 3 13 to 21 page 4 22 to 27
Your
22. Lordship, item 22. I am appearing on behalf of Mr. Rautray for the opposite parties.
22 re 22 Mr. Leka, who's brief? से adjournment चाहते थे simply posting करता लावा. Yes. तो डोरा posting करो तो computer.
we comes in 10
10 8 है week Mr. Charvi.
Much obliged, Your Lordship.
Yes. 23 to 27.
Item 21, my lord. I may be pardoned to mention, my lord.
21.
Yes, your lordship. My lord, in this matter, there is the noting came that addressee notice has been served, but it has been served on a wrong address. So I pray that I may.
Yeah, this matter mention koribe eta kemiti this have to. R1 R2 ଆସିନି ଏଠି ଆପଣ ଆଉଥରେ steps ନେବେ.
Yes, your lordship. I will send to corrected address.
ନିଅନ୍ତୁ 3 weeks.
My lord, there is an interim order. The matter was before the lower court has been adjourned till 27 of this month. So I may pray for.
Date କେବେ କରିବୁ?
we comes in
Orders ଆସିବ ଏଟା. Official
we comes in 3 है
in ଆଟରେ ହବନି ଆଜ୍ଞା. ସି ଟାଇମ ନେବେ requisite file କରିବେ ତାପରେ returnable date ହବ 17 8 କରିବାକୁ ପଡିବ.
17
Shall be listed କୋଉ ମାସ ଏଟା? ଜୁଲାଇ ଅଗଷ୍ଟ.
जुलाई 14
listed in the ଆପଣ କେବେ steps ଆପଣଙ୍କର କଣ ଜାଣିଗଲେଣି new address?
Yes, your lordship. It is available.
ତାହେଲେ ଆପଣ 7 days ରେ ଦିଅନ୍ତୁ.
Yes, requisite shall be filed. My lord.
ଦିଅନ୍ତୁ 14. Returnable date ବି fixed to 17 8 ଆପଣ ଲେଖନ୍ତୁନି. Listed in for orders in the week commencing 24 8 ଆପଣ ଲେଖିବାକୁ ପଡିବ. Yes, ଆପଣଙ୍କ ନାଁ sir Mr.
Sanat Sushovan.
Sanat Sushovan Panda. SS Panda, it is there. Yes, next.
My lord, interim order to cut.
Yes, but that order has to be passed. You have to
Yes,
wait for
yes.
that. 28 to 33. Thirty-four to 40.
Item number 35.
35.
35 in this application. Previously, I appeared for OP number 3 and 4.
Yes.
That is the president and secretary of the Hon'Ble Bar Association. But after election, new president secretary has been chosen. So I have got no instruction from them. My power may be deleted.
Wait, let us see.
My power may be deleted.
हटा delete कर देबे.
हाँ.
ना Hon'Ble केस आसुनी आपण.
No. Hon'Ble case has say president secretary sir more किछ नाही. So yeah. That I have taken instruction to today morning. They will give a new council.
Your Mr. Barik, your name sir? देखो पढ़ले कौन 35 पढ़ले. आनो. Yes, what's your name sir?
Malats, I'm appearing for the petition in item 35, Malats.
Yes sir. That is how you are being requested for your response.
Malats, I'm praying for
What's your
time.
name?
Malats. I
What's
pray
your
that
name? What is your name?
Sarthak Mahapatra, Malats. Appearing on behalf of
Mr.
Mr. LK
Sarthak Mahapatra on behalf of Lalit Kumar Maharana for the petitioner. Mr. 35 Mr. Lenka. কি আছে?
State
35 state council का नाम लिखिए आप. तापर लिखिए Mr. Arijit Misra for OP number 2 and 3.
Well, 3 and 4.
3 and 4.
The president and
Submitted
secretary.
by the Learned Council for the matter is mentioned, matter being listed, having been listed for admission, for hearing, under the heading for admission, is mentioned by the Learned Council appearing for the OP OP 3 and 4, stop. It is, he submits that he no more has instructions to appear on behalf of the OP number 3 and 4 as as the newly elected OP number 3 and 4 shall engage their
Own
counsel.
counsel. Yes.
Stop. Accordingly, the name of Mr. Arjit Misra, Learned Counsel and Learned Associate shall be deleted from the cause list as well as the case brief,
Man.
appearing for OP 3 and 4.
Man.
The matter shall be listed for admission
We commencing 17.
in the week commencing 17/8/2026.
Matlab, interim order to continue. Matlab.
Interim order as passed earlier, dated
Matlab, there was an extension of the interim order by matlab, order dated 23/7/2025. That may be continued. Matlab.
8/7/25 देखिए, okay. The interim order is reiterated. अपन लिखिए, अपन केवल date कॉल है, Mr. Bari.
17.
The matter shall be adjourned to immediately. But as you 17/8, adjourned beyond 24/8. Now, I will further read you. That is the hearing matter. So, appeal corner to me, but that list take out the rest. Commencing. Shall be.
ତାଙ୍କୁ ଇନଫର୍ମେସନ ବି ଆଗେ ପଳେଇ ଯାଇଛି ଆଜି ଆଜି ସକାଳେ ଇନଫର୍ମେସନ ଦିଆ ଯାଇଛି ସେମାନେ ତାଙ୍କ ଓକିଲ ବି ଦେବେ
ଠିକ ଅଛି ତାହେଲେ adjourned beyond shall be listed in the week commencing 24/8.
ଯଦି ମତେ ଦେବେ ତାହେଲେ ମୁଁ ପୁଣି ଆପିଲ କରିବି ଆଉ
Okay. And shall be adjourned beyond
7.
नहीं सेटा होची 31/8 ना beyond 31/8 और नेक्स्ट वीक ता अछि सेप्टेम्बर फर्स्ट वीक में 31 100 होची 31/8 beyond 31/8 2026 36 to 40
41 to 49. 52, 53.
Item 52. I am for opposite party number 8 to 12.
please inform the petitioner
Yes, my lord. I am such.
52 টা date করিবে
No, sir, date কথা ମୁଁ କହୁନି. I want that the matter should be taken out.
no priority 52 happen I take if I reach 51 I'll definitely take 52 no difficult but suddenly I start taking up 52 how is that if it reaches no difficult yes
Page 9, 54, 55.
yes next
Item 1.
mention 54 mention 54 की विषय
I beg to appear 54. May I please, Melis, I beg to mention item number 54. I appear for the petitioners. Let's
Yes.
may kindly grant me a short date. There is some difficulty
date कर
on my end.
आपण कर नो मिस्टर जी
No.
सी वॉइस क्रैक करथिला
We commencing 17.
17/8 fresh admission I'm sorry this is after notice 17/8 Ms Pandey we commencing 17/8 could you hear
Yes, Melis.
yes
Much obliged.
Much obliged, Your Lordship. Much obliged. And Melis, may kindly be pleased to continue the interim order dated 30th of November 2026.
that order is a stay order or a adjournment order
Stay order.
Yes, Melis, it's a
that
stay
remains
order.
after.
Stay order.
because to save time we are
Much
doing it
obliged.
simply posting in the computer so that helps in saving time as well as less file movement
Much obliged.
कोन मार्केट में देखि देबे मिस्टर बारिक 34 रे कोन ऑर्डर अछि केते नंबर एटा 54
54.
कॉल करो
Item 1.
Item 1, my lord.
yes please
One week time to file the affidavit whether the maintenance amount paid.
just one just give me a second stay order अछि okay I'm just getting the file. Mr. A.K. Behra for the petitioner. They're opening the file. adjournment is sought for by the Lord Counsel for the petitioner, as it has been since 21/11 on 21/11/25 16/3/26 7/4/26 4/5/26 and 7/7/26. On 7/7/26 the following order was passed, the copy paste for this. To grant further opportunity to the petitioner to comply with the earlier orders. Orders from Assam, reiterated in subsequent orders. The matter further time is granted. Plus, though it has been mentioned in the cause list that, quote, the matter shall be disposed of having been adjourned for 4 years and 8 months. The matter shall be listed as prayed for on 22/7/2026 for fresh admission.
My lord,
Within ଅଧିକା ହେଇଗଲା
28 की ରଖନ୍ତୁ।
on 28 ଆପଣଙ୍କର କଣ ହଉଛି କି ଏଟା again illegal order
ନା ନା ଠିକ ଅଛି
disposal ପାଇଁ list କଲି ତାପରେ again I do not know what I am doing.
ମୁଁ କମ୍ପ୍ଲେନ୍ କରିଦେବ 28 by 20
କମ୍ପ୍ଲେନ୍ କରିବା ପାଇଁ ତ it's not you are not doing a charity ନା ଯଦି କିଛି charitable କାମ କରୁଛନ୍ତି ଠିକ ଅଛି I would have recorded since the petitioner is going to do some charity I recall my order or modify my order. ଆପଣ ଯାହା କରୁଥିଲେ ସେୟା ହିଁ କରୁଛନ୍ତି 4.5 ବର୍ଷ ପରେ କୋର୍ଟ ବି ଆହୁରି ବଢିଆ 4.5 ବର୍ଷ ପରେ ବି ଆର୍ଜନ କରି ଚାଲିଛନ୍ତି like me. So I am able to tell this because I am the court. Otherwise କଣ ମୁଁ କହିପାରିଥାନ୍ତି I cannot comment but I can have a comment on me what I am doing. କଣ ଲେଖିଲେ 22/7/24 with the same noting under the heading fresh admission. Develop a habit of talking straight to the client. That helps us to being a lawyer.
Item 2.
ଆପଣ ଉପରକୁ ଗଲାନ୍ତୁ ମୁଁ କଣ କରୁଛି ଆପଣ ଯଦି ଇଏ ଆପଣଙ୍କୁ ଡରୁଛନ୍ତି କି କ୍ୟା କରୁଥାନ୍ତି ନା ପ୍ରଥମ ଦିନ ଏଇଟା that is the difference of the collectors. And the petitioner whether and it's part. On several occasions, no one has been appealing for the petitioner. That is a very huge service. That is service. The intermittent appearance on behalf of the petitioner has been on. No child service. And part service. Why does it be listed? Does we commencing at court to program?
So,
We commencing the OBC. Or this is Saturday.
Saturday. 27 কিংবা 27 এটা আইজি স্যার প্রতিনিধি না নন
IC Saturday 24 for fresh admission indicating in the first list that disposed of remain adjourned. Four occasions and 26 walking police and waiting for more than 3 years. 6 knocking police. Yes.
Item 6.
My lord, I am appearing on similar. I need. Yes, I need 15 days more time, my lord. My lord, I want 15 days more time to file affidavit, my lord.
Status, my lord, 96,000 is dues. Say at the time of arrest, the opposite party number 3, he has paid only 14,000, and opposite number 2 has paid 7. Lekha mupkare. No, straight no. ସେ ଭଡା ନେଇକି ଅଛନ୍ତି।
My lord,
ହଁ ନା arrest ହେଲା ବେଳକୁ ସେ opposite partner 2 has paid 14,000, opposite partner 3 has paid 7,000 only. All other dues are pending, has not paid. I am for the father of the opposite parties.
my lord, I will ask for the details documents from the client, my lord. I will file affidavit, details affidavit.
So lordship on last occasion, lordship directed to file affidavit.
Present in Control and Mr. Service. This understand it's only this is further adjournment. To remain present physically.
For filing of affidavit thila.
Filing of affidavit, my lord. I will file affidavit, my lord, with all details.
Opposite party refers to the order dated 26. Paragraph 5 and subject said that the affidavit has not been filed. Last time, so. We have followed up the petitioner. listed for fresh admission and the recommencing.
3-8.
Yes, my lord. I will file affidavit, detailed affidavit.
Item 8.
Item 8, my lord.
Yes.
In this case, I am for the petitioner. Challenging the judgment passed by the family court, my lord, against the wife, my lord. My lord. Yeah, case that's like advocates brief, advocates brief.
Same thing, the next case, just argue the opposition.
In that case, I
Go ahead.
that case I am for the father. In this case, husband.
Other hand child.
In this case, only 3 points, my lord. 1 point is yes, my lord. I filed. 1 point is due to affidavit I have filed, my lord. Last. 3 affidavit wife, husband, and the father of the wife.
Advice. Can you look at the order dated?
My lord.
Is there?
My lord.
It's a.
10 seconds. সেটা কইଥିଲି
Paragraph 6.
yes, my lord. In this case, I just saw.
Paragraph 6 start with this. Paragraph 3.
Paragraph 3 page petition. No order. Sorry. Order terminated. Order taken by. My lord. My lord. My lord.
To did not re-argue the matter. Then 6, candidate 6.
My lord.
The petitioner needs to advise. Read how the authorized, how they ready.
Source of amount. Instruction.
Devendra Narayan Patnaik for the petitioner. The learned counsel for the petitioner has further accommodation as directed further accommodation and obtain accommodation to obtain instruction and file affidavit on behalf of the petitioner as directed by order dated 30/4/2026, paragraph 6. The learned counsel shall also advance further arguments as observed in response to paragraphs 3 and 4 of the said order. Matter shall be listed for fresh admission in the week commencing 10/8/2026.
Okay.
Item 9.
The A.K. Behra for the petitioner. वकालतनामा है नहीं, not complete. No one appearing from Mr. Bhuyan chamber?
My lord.
They appear, let it be urgent, appear Corina as it seems. Mr. A.K. Behra for the petitioner, first matter, 311. Office note indicates that wakalatnama on behalf of the opposite party has not been filed. As undertaken, and recorded by order dated 30/6/2026. Awaiting appearance of the opposite party, the matter shall be listed for fresh admission in the week commencing 10/8/2026. Second matter रे कौन उभय appear कर जाइछन्ति?
Yes, sir.
अच्छा, second रे petitioner none, opposite party Mr. A.K. Behra.
Yes, ma'am.
In view of the orders passed in the tagged RPFF 311-2025, the matter shall be listed together along with the said case on in the week commencing
10-8.
10/8/2024.
Item 11,
Mr. Dwarika Prasad Mahanti for the petitioner.
Yes, my lord. Item here, an application for transfer of the proceeding. The proceeding has been initiated at Just Family Court Keonjhar, that is under section 13 of the Act,
By the husband,
by the husband.
opposite party.
Yes, now
Yes.
the wife is staying with her father at in the district of Mayurbhanj. His village is Indupur. That is a quite distance place, but he wants to praise for transfer of the case to Karanjia. That will be nearer to both the husband and the wife, because coming alone to Keonjhar, which is about 55 to 60 kilometers, you know, because Indupur to.
But those areas, Mr. Mahanti, if you have any idea of that area?
Not much. I have gone to Varipada.
So let me speak for having idea. Those areas actually it is very well connected and integrated.
Connected road.
Mayurbhanj and Kendujhar, not in that sense. Connected, of course, road. I'm not speaking about roads. People from those areas, they live in Kendujhar. The state, I mean, they permanently reside in Kendujhar.
Oh, I see.
Because Kendujhar is small. Perhaps because Baripada is a distance place and Kendujhar is within 30, 40, 50 kilometers. So many of them have settled in Kendujhar.
The father of this lady, he is only a Brahmin. He is a Pujak.
He might be staying in Kendujhar also. Let us see.
No, he's.
How many cases the lady has filed against the husband?
No much.
No cases.
This is the.
That's good. Because the helpless lady files 5-6 cases against the husband. Then comes to High Court and says that I am so helpless that the case filed by the husband should be transferred to my place where I have filed 5 cases. In one case in Bhubaneswar, she has filed 2 FIRs in different police stations.
When he was staying with her husband, when the dispute started at Keonjhar, his only child was studying at Keonjhar by then. He was also.
No, this is not the case. This is not. She is not that helpless that she has filed 5 cases. He is only helpless to the extent that staying with parents. Had Mr. Mahanti, the appellant accused, had learned counsel for the petitioner. The petitioner before this court is the. You can have your seat. I'll be complete down.
Yes.
The petitioner before this court is the wife in the marriage. Now, by filing the application under section 24 of the CPC, 24 of CPC, the C6 transfer of CP number 10502025 pending before the learned judge Family Court Kendujhar to the Court of Learned Civil Judge Senior Division, the Senior Civil Judge.
Senior Civil Judge coach.
The Court of Senior Civil Judge Karanjia in the neighboring district of Mayurbhanj. Senior Civil Judge
Right. Sir, Civil Judge
After
Senior
amendment.
Again?
Senior Civil Judge
Junior Division will lekha khali Civil Judge. Junior.
Junior Division uthigala, Assistant Session Judge uthigala.
केवल सिविल जज माने ऑटोमेटिकली जूनियर
ऑटोमेटिकली
एमाने होचन सीनियर सिविल जज
He submitted that after the petitioner's marriage has run into rough weather, sister stays with her parents at village
Indupur in the district of Mayurbhanj.
At village Indupur in the district of Mayurbhanj. And Karanjia is the nearest court. He submitted that Karanjia is not far off from Kendujhar. Stop. Maintenance भी फाइल करना है.
हाँ, RPF में इतला केओंझर बेले सेटा सॉरी जी.
For issue notice to the opposite party along with this order. Requisites for issuance of notice by speed post with registration and proof of delivery shall be filed within 5 working days. Returnable date be fixed to
17/8.
17/8. The matter shall be listed for orders on 24/8/2026. Then IA 166 of 2026. Third Learned Counsel for the petitioner, he reiterates his submissions as noted above. Issue notice as above, accept one set of process fee as well as postal requisites. Stop. So para the returnable date as well as the next date of hearing shall be as directed above. In the interim, it is when Sapara, it is in the interim, it is directed that the CP number so and so, pending report so and so, shall be adjourned to a date beyond 24/8/2026 as would be convenient to the learned court in season of the matter upon a prayer being made for the said purpose.
Item 12.
May I please, your lordship?
You are Mr. Das.
Mithun Das, my lord.
Mr. Mithun Das for the petitioner. I think your get-up has changed. You have grown a beard or what? Earlier you were not having.
Yes, my lord.
Okay. So that is how I could not, a little bit,
My lord.
by name I try to recognize. So Mithun Das for the petitioner. Yes, Mr. Das.
My lord, the petitioner wife.
Yes.
Transfer of CP number 38 of 26, pending the Lord Family Court, Family Judge Bhadrak to the Judge Family Court Keonjhar. As because, my lord, the opposite party already resides in the jurisdiction of the Keonjhar. Is open page 3, my lord. I have, my lord.
That is not a ground.
My lord.
Place of stay of opposite party cannot be the basis of
My lord,
judgment.
already
So you argue law, sir. Mr. Das, you argue law. You are sufficient.
My lord, page 18.
No, you come to the point. Page 18, what is your argument to seeking transfer?
Bhadrak, se jehetu rohuchandi, my lord, Jhumpurare in
Kiye
Keonjhar.
rohuchandi?
Wife, the petitioner. Petitioner is the wife
So
of
can that be the basis of transferring a CP
my lord.
before from the court having jurisdiction?
Helpless, my lord, because he has a male child.
After becoming helpless, how many cases he has filed against the husband?
He has filed 2 cases, my lord. In
Two cases?
Jhumpura case.
So
Annexure 1 and Annexure 2.
all are Bharatiya Nyaya Sanghita. So when after she has become helpless, she lodges. Ajmani has 2 cases, and how many proceedings pending?
Madam, my lord, Annexure 3, 1 CMC is pending before the London SDGM Chompua, and also he has appeared as because he is residing.
She has to, otherwise he will be arrested.
Because my lord,
Because the wife having becoming helpless files cases against the husband.
my
Chompua, he has to appear.
my humble submission, my lord, before your lordship.
No, any case law on this, wherever the wife files criminal cases, all the cases has to be transferred there.
Bhadrak, my lord, distance is
अरे मते आपण गोटे उत्तर देबे ना ये गोटे कथा parallel कहबे आपण भी कहबे. So please answer. Any case law that wherever the wife chooses to file criminal cases against the husband, all cases has to be transferred there. Any provision in law, first, second, any case law.
I will file, my lord.
Try to find, sir.
I will, lord.
There is no such law. Assist the court to pass some legal orders, not based on common logic, contrary to law, and the learned counsel for the petitioner is heard at some length. The petitioner before this court is the wife in the marriage. C by filing the present application under section 24 of section 24 read with section 151 of the CPC, 1973. 6 application for transfer of CP case number 38 of 2026. Pending before the Court of Learned Judge Family Court Bhadrak to the Court of Learned Family Judge Kendujar. To support the prayer of transfer, it is submitted that the wife is helpless. She stays with her parents at where she stays now?
Jhumpura, my lord.
Stays with her mother at Jhumpura along with the child. The further argument on behalf of the petitioner is that since the wife has filed FIR at Jhumpura PS, under provisions of Bharatiya Nyaya Samhita such as sections 85, 100, 115 into bracket 2, 351 into bracket 2, 3 into bracket 5, and Dowry Prohibition Act 4. That is Jupura PS case number 52 of 2025, the semicolon. Jupura PS case number 145 of 2025, dated 23/25, invoking the self-same sections. The petitioner, the CP filed by the husband should be transferred to Kendujar, which is the court, to the court of Learned JFC Kendujar, which is nearer to Jopura. It is further submitted that the petitioner wife is not maintained. Petitioner wife and child are not maintained by the OT husband. CMC number 178 of 2025 has been filed pending before the Learned SDJM Champua. Under section 144 of BNSS, 2023, seeking monthly maintenance. Stop. The Learned Counsel for the petitioner shall apprise this court regarding the case law or provisions of law under which the CP number 38 of the CP file number, the CP filed by the husband seeking restitution of conjugal rights under section 9 of the Hindu Marriage Act can be transferred. In view of the specific provisions of the CPC section 9, Family Courts Act section dash, Hindu Marriage Act section dash. Family court code पढ़ा आपने? Section 9 लिख ले. Family Courts Act section 7. Hindu Marriage Act 18. Notice be issued to the opposite party along with this order. Indicating that the matter is likely to be disposed of at the stage of admission. Stop. Requisites per issue submitted by speed post with registration of proof of delivery shall be filed within. How much time, Mr. Das?
As your lordship.
As your lordship, nahi actually. As your lordship,
within a week.
Within 7 working days. Within 5 working days. Week shall be filed within 5 working days. Returnable date be fixed to 17/8. The matter shall be listed for orders in the week commencing 24/8. Para. IA number 215 of 2026, 215 of 2026, had Learned Counsel for the petitioner. He reiterates his submissions as noted above. Issue notice as above. Stop. Accept one set of process fee as well as postal requisites. The returnable date as well as the next date of listing shall be as directed above. In the interim, it is directed that the CP number 38 of 2026 pending before the learned judge family court Bhadrak shall be adjourned to a date beyond 31/8/2026 as would be convenient to the learned court in season of the matter upon a prayer being made for the said purpose. Next.
Not appeared.
Item
Sorry,
30,
sir.
The petition have not appeared till later.
ସେଟା ହବନି
My lord.
ଆପଣ ଯଦି ଏଠି ଭଦ୍ରକରେ ଆପଣ ଏଠି କେସ୍ କରିବାର ଦରକାର ହିଁ ନାହିଁ କିନ୍ତୁ ହାଇକୋର୍ଟରେ ଜଣେ ଓକିଲ ଉପରେ ଏନଗେଜ ହେଲେ
No, my lord.
ଭଦ୍ରକରେ ବି ଓକିଲ ଏନଗେଜ ହେବେ ନା ଆଉ
My lord, my lord. My lord.
ଏଠି କଣ ଦରକାର ଏଇ କେସ ର କିଛି ଅଛି ସେକ୍ସନ 9 ରେ ଆପଣଙ୍କ ଷ୍ଟାଣ୍ଡ କଣ ସେକ୍ସନ 9 ରେ ଆପଣ କଣ କହିବେ ଦ୍ୟାଟ ରେଷ୍ଟିଟ୍ୟୁସନ କରି ହବନି ବୋଲି ସରିଲା ଲାଷ୍ଟ ଡେ ରେ ମ୍ୟାଟର ଇଜ ଓଭର ସେଟା ଆସି ଝୁମ୍ପୁରା ଯାଇ ଭଦ୍ରକ ଯାଇ କଟକ ଆସି ତାପରେ ସେଠି ଓକିଲ ଭଦ୍ରକ ଓକିଲ ଆପିୟର କରିବେନି ସେକ୍ସନ 9 ରେ ଆପଣଙ୍କର ଯଦି ଇଏ ହବ ଆପଣଙ୍କର ୟୁ ମେ ଗେଟ୍ ଏ ଡିଗ୍ରୀ ଆପଣ ଷ୍ଟାଣ୍ଡ ସେୟା ନେବେ ଯେ ବିକଜ ଅଫ ଟର୍ଚର ଅର ହ୍ୱାଟ ଏଭର
Obliging.
ୟେସ୍ ଆପଣ
Item
ଭଦ୍ରକ
30
ଯାଉଛନ୍ତି ଟ୍ରାଏଲ ରେ କରିବା ପାଇଁ
ସେଟା 1908 ହବ ଚିପିସି ଟା
1108 ସେ ସେଥିରେ ଲେଖିଛନ୍ତି କିନ୍ତୁ ଅଲଗା ବୋଲି ମୁଁ ଦେଖିକି ଡାକେ ତ ଆଇ ହାଭ୍ ହ୍ୟାବିଟ ଅଫ ଲୁକିଂ ଆଣ୍ଡ
Sorry.
1908 1908 amended up till date amended up to date पर till date लिखिए तो निरंजन लेखा पर the petitioner
in no lordship may
Mr. Naik for the
One.
additional standing counsel for OP1 yes please affidavit copy टा पाइछन्ती आपण
yes yes
but there is affidavit Mr. Naik you have copy yes Mr. Link
Yeah, my lord, I have already filed the that
that-
affidavit
that-
in compliance
that is
of the
with,
order dated
reference
12/3
to order dated
12/3/2026.
12/3/20
Pursuant to that, the affidavit has been filed here, my lord, the order passed by the learned permanent and continuation
अच्छा, से
further.
जो ଆପଣଙ୍କର
ହଁ
to
ମୁଁ
decipher what is the plot number ଖାତା number ବୁଝି ହଉନଥିଲା actually
ହଁ ମୁଁ ସେଟା affidavit ରେ ଦେଇଛି ସେ ଦେଇଛି ଯେ
that helps ଜଣା ପଡୁଛି
ହଁ ସେଟା ସେ
ଯେ ଆପଣ comparative କଲେନି ପ୍ରୋବ୍ଲେମ ହଉଛି ଯେ ଆପଣ କଣ କଲେ ନା ଏଇ ଜିନିଷ ଡାଟା ସାର୍ ଅଛି already this is not required ଆପଣ order is very specific
ହଁ
this data is not necessary to be reproduced again ଠିକ ଅଛି ଆପଣ collect କରିଦେଲେ
ହଁ,
but
ମୁଁ-
kindly again go back to that order
here
para 4 to demonstrate the said submissions and you look at order dated 12/3/26
ହଁ
ସେଠି ଖୋଲି ଦିଅନ୍ତୁ ଆଜ୍ଞା
ମୁଁ ଏଠି ପଛ
order ଟା ଖୋଲନ୍ତୁ ଆପଣ ପାଖରେ ଅଛି that should be used by you you are not that old Mr. Linkard not to use
ମୁଁ କରିସାରି
welcome
To demonstrate the said submission, the petition who are not parties shall file affidavit giving in tabular form.
then kindly be slow read slow comparing the schedule of property the details of genealogy indicating the share and development of the property compared to the schedule of property that was subject matter of suit which was disposed of
Yes.
so and there are so many plots and so many persons it was not clear that what was in the suit and what is the property ସେଇ comparison ଟା actually ଦରକାର ଥିଲା ଆପଣଙ୍କର ଏଇ ଯୋଉ have you understood have they explained you that regarding genealogy ବର୍ତ୍ତମାନ କିଏ କାହା କାହା ଭିତରେ କେସ୍ ଚାଲିଥିଲା
Genealogy ରେ ମୁଁ
page 2 ରେ ଦେଖନ୍ତୁ ପ୍ରାଣକୃଷ୍ଣ ପ୍ରଧାନ of your affidavit
he is the common ancestor.
ପ୍ରାଣକୃଷ୍ଣ is a common ancestor
Yes,
ବର୍ତ୍ତମାନ case
we are
ଚାଲିଥିଲା।
the sons of two daughters of Pranakrishna, that is Shailabala and Pramila.
ସେଟା ଲେଖା ହେଇନି
ହଁ
ଆପଣ
ଆମ
ଯୋଉମାନଙ୍କୁ
case ଟା
training ଦିଅନ୍ତୁ
ଆମ
ସେ
case
ଆହ୍ୱାନ ଲେଖିବେ ନା ପିଟିସନ P1 P2 ସେଇଠି ଦିନରେ ଲେଖିବା କଥା ପ୍ରମିଳା ଶୈଳବାଳା ହଉଛନ୍ତି ବର୍ତ୍ତମାନ ପିଟିସନର
ନାଇଁ ତାଙ୍କ ପିଲା ଆମେ
ମାନେ
ଆମେ ନାତି ଅଜାଙ୍କ ସମ୍ପତ୍ତିରେ ସେୟାର ଟା ଚାହୁଁଛୁ
ଶୈଳବାଳାଙ୍କର ତ କେହି ପିଲା ନାହାନ୍ତି
ହଁ ଶୈଳବାଳର ହେଲା ପ୍ରତିମା ହୃଷିକେଶ
ଇନ୍ଦ୍ରମଣି ନା ଆଉ
ନାଇଁ ଇନ୍ଦ୍ରମଣି
ଆପଣ ଘୁଞ୍ଚେଇ ଦେଇଛନ୍ତି
ହଁ ସେଟା ମୁଁ ସେଟା ନିଜେ କରିଛି ତ
ଠିକ ଅଛି ଶୈଳବାଳାଙ୍କର ପିଲା ହେଲେ ପ୍ରତିମା ହୃଷିକେଶ ପ୍ରମିଳାଙ୍କ ପିଲା ହେଲେ ପ୍ରଦୀପ ଏ ରିଟ୍ ପିଟିସନରେ ପ୍ରତିମା ହୃଷିକେଶ ପ୍ରଦୀପ ହଉଛନ୍ତି ରିଟ୍ ପିଟିସନ
ହୃଷିକେଶ ଆଣ୍ଡ ପ୍ରଦୀପ ହଉଛନ୍ତି ରିପିଟିସନ
ପ୍ରତିମା କରିନାହାନ୍ତି
ପ୍ରତିମାକୁ ଆମେ କରିନୁ ସେ ତ ବାହା ହେଇକି ରହିଛନ୍ତି ବାହାରେ ତ
ଆଉ ସେମାନେ ଶଳେ ଭଳିଆ ବାହା ହେଇଛନ୍ତି ବୋଲି କରିନାହାନ୍ତି
ନା ନା ନା।
if I accept that
ସେମାନେ
logic
ତାପରେ ଆମେ ପାର୍ଟି ହେଲା ପରେ
ଆପଣ
ଆମେ ସେ
ନିଜେ
କଥାଟା
ଆପଣ
ଉଠେଇବୁ।
ନିଜେ ଆପଣଙ୍କ ଭଉଣୀ
ନାଇଁ
କରୁନାହାନ୍ତି
ନାଇଁ ଆମେ ସେ ପାର୍ଟି ହେଲା ପରେ ସେଠି ସେ
ମାମୁଁ ଯେତେବେଳେ ଆପଣଙ୍କ ମାଆକୁ କଲେନି that you are making a issue
ନାଇଁ ନାଇଁ ଆମେ ସେଟାକୁ ପାର୍ଟି ହେଲା ପରେ ତାକୁ ସେଇ କ୍ୱେଶ୍ଚିନ୍ ଟା ଉଠେଇବୁ ଆମେ ସେଠି ପାର୍ଟି ହେଲା ପରେ ସେଟା ଆମକୁ ପୁରା ସ୍କିପ୍ କରିଦେଇଛନ୍ତି ତାଙ୍କ ଭିତରେ
ସାର୍ କଣ ଆପଣ ତ ସେଠି ଫେର ପଛକୁ ପଳେଇଲେ ରିଟ୍ ପିଟିସନ ରେ ଆପଣଙ୍କୁ ପଚରା ହେଲା ଯେ ଋଷିକେଶ ପ୍ରଦୀପ ଆସିଲେ ପ୍ରତିମା କୁଆଡେ ଗଲେ ଆପଣଙ୍କୁ ଉତ୍ତର ହେଲେ ଯେ ପ୍ରତିମା ବାହା ହେଇକି ରହିଲେ
ନାଇଁ ନାଇଁ ପ୍ରତିଭା ଅଛି ମାନେ ଆମେ
କିନ୍ତୁ
ତାକୁ
ଯେତେବେଳେ
ସିଏ ଆସିନାହାନ୍ତି
ମାମୁଁ ଆପଣଙ୍କ ମାଆକୁ କଲେନି ପାର୍ଟି ସେଟା ଆପଣ ଏଥିରେ ରିଟ୍ ରେ ରେସ୍ କରୁଛନ୍ତି
ନା, ନା,
ତାପରେ ଠିକ ଅଛି ଯୋଉ ପ୍ରପର୍ଟି କୋଉ ପ୍ରପର୍ଟିଟା ଆପଣଙ୍କର ସୁଟ ରେ ପାର୍ଟ ଅଛି
ଯୋଉ ପ୍ରପର୍ଟି ମୁଁ ଦେଇଛି
ପାରା 4 ରେ ପାରା
ପାରା
4
four।
ସେଇଥିରେ ଦେଖନ୍ତୁ
ପାରା 4 ରେ ଯୋଉଟା ଦେଇଛି
କୋଉ ପ୍ରପର୍ଟି ସେଟା ବି ଲେଖି ନାହାନ୍ତି
ଟୋଟାଲ ଏଣ୍ଟାର ପ୍ରପର୍ଟି ଅଛି ସୁଟ୍ ରେ ଏଣ୍ଟାର ପ୍ରପର୍ଟିଟାକୁ ସେମାନେ ପାର୍ଟିସନ କରି ନେଇଯାଇଛନ୍ତି ବିହାଇଣ୍ଡ ଆୱାର ବ୍ୟାକ୍
ମାନେ ଏଣ୍ଟାयर ପ୍ରପର୍ଟି ସବଜେକ୍ଟ ମ୍ୟାଟର ଅଫ ଦ ସୁଟ
ୟେସ୍
had nodded counsel for the petitioner at some length the apparent package खाली OP1 2 to 7 के flag the nodded counsel for the petitioner refers to the order dated 12/3/2026 wherein at paragraph 4 the following was directed reproduced further it is submitted that in response to the said order affidavit on behalf of the present petitioners has been filed affidavit dated was it 6 July 2026 6 July 2026 has been filed which is on record referring to the affidavit dated 6 July 2026 filed on this applicant এটা কোন এমতি ହେଲା স্টেট লেখা କାଲି look at the copy ଆପଣ ଆପଣ ପାଖରେ କଣ ନଥିବ ନା ଏପଟେ ଦେଖନ୍ତୁ affidavit ଟା ଟଚ୍ କଲେ
6 ଜୁଲାଇ
ଉପରେ ଲେଖି ନାଇଁ affidavit ଟା 8/7 କଣ ଲେଖା ହେଇଛି ଡେଟ୍ କଣ 6/7
5
ନାଇଁ
5 से ସ୍କାନ୍ କଣ ଭୁଲ
ଦେଖନ୍ତୁ ସୁରେନ୍ଦ୍ର ପ୍ରସାଦ ଧଳ ଆପଣ ତ ଷ୍ଟାଫ୍ ନଥିବ କୋର୍ଟ ଫାର୍ଷ୍ଟ ପେଜ ଦେଖନ୍ତୁ affidavit ଟା ଟଚ୍ କଲେ
ହଁ
ସୁରେନ୍ଦ୍ର ପ୍ରସାଦ ଧଳ 8/7 ଫାର୍ଷ୍ଟ ପେଜ ଜାଣିପାରୁନାହାନ୍ତି ତଳେ ଦେଖିବେ ସୁରେନ୍ଦ୍ର ପ୍ରସାଦ ଧଳ
ଦେଖିବେ
8/7 ତାପରେ ସେକେଣ୍ଡ ପେଜ ରେ 5/7
ସେ ବୋଧେ ଭୁଲ
ଥାର୍ଡ ପେଜ ରେ 5/7
ମୁଁ ସେଟା
ଧଳ ସାରଙ୍କର ଗୋଟେ ପ୍ରୋବ୍ଲେମ ହେଲା ସେ ବହୁତ affidavit କରନ୍ତି ସନ୍ଧ୍ୟାବେଳେ
ମୁଁ ସେଟା ସାର୍ 5 ରେ ପ୍ରଡ୍ୟୁସ କରିଥିଲି କୋର୍ଟରେ ଆପଣ କହିଲେ
ନାଇଁ ତଳେ 5 ଅଛି କିନ୍ତୁ କଣ ହେଇଯାଇଛି 5 ଟା 8 ଭଳିଆ
ହଁ
ଲେଖା
8 5 ବୋଲି ଲେଖିଛି ଭୁଲ
କଣ ଲେଖିବ
ତଳେ ଅବଶ୍ୟ 5-7 ଲେଖିଛନ୍ତି
ନାଇଁ 6 affidavit dated 5/7/2026 has been filed on 6/7/2026 ତାପରେ ଲେଖିବେ which forms part of the record which forms part of the court records but records କରିବେ ଠିକ ଅଛି referring ତାପରେ stop referring to ନାଇଁ referring to the said affidavit କରିବେ ସବୁ ଜାଗା ତ ଲେଖା ହେଇଗଲା referring to the said affidavit paragraph 2 the learned counsel draws attention to the genealogy to submit that the Pranakrishna Pradhan is the common ancestor. The present petitioners are the grandchildren of Pranakrishna Pradhan through his two daughters, Salavala and Pramila. They also represent the sister of Rishikesh. Petitioner, PW?
Two.
PW2. PW petitioner 2 in the writ petition, Pratima. The learned counsel then refers to the schedule of properties as mentioned in paragraph 4 of the affidavit. That is the subject matter. That is no, which are the subject matter in the P and C case number 46 of 2021. It is submitted that corresponding to Khata number 215, several plots as mentioned in paragraph 4, the entire suit schedule property has been partitioned without giving any share to the present petitioners, along with their sister Pratima, who are descendants of the daughters Shalabala and Pramila. Daughters to sisters Shalabala and Pramila, daughters of Pranakrishna. Para, in considered view of this court, it is further reiterated by the learned counsel for the petitioner that the petitioners are vitally interested in the properties being shareholders or legal heirs of shareholders, but they have not been made parties. The order and decree has been obtained behind their back, they having not been given any opportunity. So, having heard learned counsel for the petitioner, in considered view of this court, the petitioner has prima facie made a case for issuance of notice by following and applying the principles laid by the Honorable Apex Court in Jalor Singh, in state of Punjab versus Jalor Singh. In a challenge to the order passed by the Lok Adalat, National Lok Adalat. The national
permanent and continuous Lok Adalat.
Challenge to the permanent continuous Lok Adalat under the provisions in the E court se jo apanakara Legal Special Authority Act. Anyway, chhad diya. Lok Adalat, permanent continuous Lok Adalat, full stop. Requisites for the additional standing counsel of an advance copy served appears and waives notice on behalf of the OP number 1. Copy has been served on the learned additional standing counsel. No further notice be issued. Stop. Para. Notice be issued to opposite parties to TO27 by speed post with registration and proof of delivery. Stop. Requisites for issuance of notice be filed within 5 working days.
By Friday.
Within 5 working days. List after SR, devoted to the returnable date be fixed to 17/8/2024. The matter shall be listed for orders in the week commencing 24/8/2024. Then IE 3391 of 2026. Hard learned counsel for the petitioner. He reiterates his submissions as noted above. Issue notice as above. Accept one set of process fee as well as postal requisites. Learned additional standing counsel appears and waives notice on behalf of OP number 1. Stop. As an interim measure, it is directed that the award / order dated 19/2/2021 passed by the learned judge P and C into bracket LA, Kendrapada, shall remain stayed until further orders. Stop. Colon kar diya, semicolon, comma par bhi semicolon. The parties shall maintain status quo regarding nature, character, possession, ownership of the properties of which the schedule has been properties, details of which has been indicated indicated at paragraph 4 of the affidavit dated 5/7/2026 until further orders. Urgent certified copy be issued as per rules. Yes, please.
Item 14.
Pass over कर देबे
15.
pass over कर दियो
16.
रविंद्र कुमार पृष्टि for the petitioner. Other side पे appear कले रामकृष्ण नायक ना अपन associate से
No.
Eh?
Madam is on behalf of the opposite party.
अच्छा मैडम yes madam.
We have filed our
S Das for the opposite party. Yes please.
a copy of the resolution may be served on.
Notice है नहीं कुछ
No matter.
अच्छा fresh अच्छा ठीक है though the matter is listed for fresh admission Ravindra Kumar Pusti for the petitioner opposite party blank छाड़ी था ना please ने अपन appear करके record ऐसे लें तो ठीक है Mrs. S Das for the opposite party though the matter is listed for fresh admission it is submitted by learned counsel MS S Das that she has instructions to appear. She has filed a duly executed Okalatnama on behalf of the opposite party. Accordingly, copy of the writ application shall be served on Mrs. Das during course of the day. The matter shall be listed for fresh admission. Kebe madam, kebe asle habo?
Madam already appeared and I have served the copy. The learned court below has posted to 3rd August as a last chance for argument. So any date we fix.
Kebe aile habo? 3rd August mane aji hochi we commencing 14 we commencing 20 na kete 27 kebe?
For 20th is Monday.
20 week re asibo na 27 week re asibo? Oh, ठीक है. The matter shall be listed for fresh admission in the week commencing 27/7/2026. What best can be done, Mr. Pushti here? Why
Because
this?
my lords, after obtaining the husband, please, I am
See, upon against the order to move order to silent. It is called order to silent.
Husband filed an application under section 13. Wife appeared. Thereafter, did not choose to contest the case. On the other hand, the file one DP case, and in that case, he was regular getting the interim maintenance. What has happened? 100% correct. 100% correct. Thereafter, what has happened?
But there is the aspect.
Well, the aspect is after when the
ଆପଣ ଯେତେବେଳେ fees ପାଇଁ କହିବେ wife କହିବେ ଆଜ୍ଞା ମୁଁ ତ maintenance ପାଉନି ଆଉ କଣ କରିବି ମୁଁ କୋଉଠୁ ଆଣି fees ଆପଣଙ୍କୁ ଦେବି ତାହେଲେ ଠିକ ଅଛି ଆସନ୍ତୁ ଆହୁରି case file କରିବା 120 file କରିବା
appear କଲେ
DP file କରିବା
appear କଲେ କିନ୍ତୁ
20 file କରିବା
appear କଲେ contest କଲେନି expiry divorce
ବର୍ତ୍ତମାନ order 913 ହେଇଗଲା
order 9 that expiry divorce allow ହେଇଗଲା thereafter 913 application filed. After closing of the evidence, I filed 1817 application to recall the wife in order to prove 2 certified copy.
Recall of witness file.
In order to mark exhibit 2 certified copy. That has been rejected. Against that.
Madam, ठीक अछि, I got the point. Madam, सुनंतु, मो कथा टिके सुनिबे ता पर कारण आज तो किछ order होउनी. So it is not adversarial. बुझिपारले. This is more kind of understanding the law and this position, हैला. ଆପଣଙ୍କର difficulty କଣ ଅଛି recall ହେଲେ?
No, more is difficult, but after closure of evidence, after long gap of 1 year, for what prevented him to file the recall petition?
ଆଜ୍ଞା order 913 ଆପଣ ଫାଇଲ କରିଛନ୍ତି?
ନା ମୁଁ ଫାଇଲ କଲି ଯେ to refer
ଆପଣ ଆଜ୍ଞା ଏକ୍ସପର୍ଟ ହେଇଗଲେ ସେତେବେଳେ ତ ଆପଣ ଶୁଣନ୍ତୁ ଆଜ୍ଞା ସେ ଯଦି କହିବେ ଆଜ୍ଞା order 9 rule 13 divorce ହେଲା ପରେ order 9 rule 13 ଫାଇଲ ହେଲା କାହିଁକି ସେ ଆଜ୍ଞା ହବ? The same question, please apply the analogy, logical analogy, legal also. In a divorce CP filed under section 13, you have been set ex parte. The decree is granted. Now in order 9 rule 13, if ଆପଣ ଏଟା କନସିଡର କରନ୍ତୁ 27 ତାରିଖରେ ଆସନ୍ତୁ so that that will help you.
Objection, judges.
ଶୁଣନ୍ତୁ ଅର୍ଡର 9 ରୁଲ୍ 13 ଟା ଆପଣଙ୍କର
My lord.
ରେଷ୍ଟୋର ହେଲେ କାହାର ଲାଭ ହବ
More than habo.
ଏକ୍ସାକ୍ଟ so that is the logic I am trying to give you. ଯଦି ଅର୍ଡର 9 ରୁଲ୍ 13 ରେ ସିଧା ରିକଲ୍ କରିଦେଲେ ଦିଟା ୱିଟନେସ୍ କରିଦେଲେ ସେଟା ଆପଣଙ୍କ ପିଟିସନ ଟା ଅର୍ଡର 9 ରୁଲ୍ 13 ତ ସାର୍
Order 9 rule 30.
ରୁଲ୍ 13 ପେଣ୍ଡିଂ ଅଛି ତାହେଲେ ଠିକ ଅଛି ମୁଁ ଠିକ ବୁଝିଛି
ଡେରିରେ ଫାଇଲ
ଆଜ୍ଞା ବହୁତ ଡେରିରେ ଆଜ୍ଞା ଆପଣ ତ ବିଲକୁଲ ଆପିୟର କରିନଥିଲେ that is to be condoned.
ସେଟା
ଆପଣ ଯୋଉ ବିଲକୁଲ ଆପିୟର କଲେନି ଅର୍ଡର 9 ରୁଲ୍ 13 ଆପଣ ଶୁଣନ୍ତୁ ମ୍ୟାଡାମ ଆପଣ ତ ଡିଭି ରେ ଫାଇଲ କରୁଥିଲେ ମାନେ ଆପଣଙ୍କ କ୍ଲାଏଣ୍ଟ ଡିଭି ରେ ଆପିୟର କରୁଥିଲେ ରେଗୁଲାରଲି ପଇସା ନଉଥିଲେ
ନା ଡିବିବି ଡିସମିସ୍ ହେଇଥିଲା ନିହାତି ଯେତେ ଥିଲା ଲକଡାଉନ ହେଇଛି
ତ ଆହୁରି ବଢିଆ ତାହେଲେ ଡିଭି ବି ଏକ୍ସପର୍ଟ ହେଇଗଲା ଆପଣଙ୍କ ମାନେ ଏଗେନ୍ଷ୍ଟ ରେ
ହେଇଛି
ଆପଣ ତ କୋଉଥିରେ ବି ଆପିୟର କରୁନାହାନ୍ତି
ନା appear
ଆଚ୍ଛା ଅର୍ଡର 9 ରୁଲ୍ 13 ରେ ଯଦି ସେ ରିକଲ୍ ହେଇଗଲେ ୱିଟନେସ୍ କଣ ଅସୁବିଧା ହେଇଯିବ
କିଛି ନାହିଁ ସେମିତି
now the question is that why the court is interested court is not interested for only this purpose that in a CP which has been dismissed ex parte order 9 rule 13 is again filed so it is yet to be decided order 9 rule 13 allow hela pore tapare kon hobo suit will be restored to file dismiss hele apon fere ठीक आसीबे so where we are heading for madam
ଆମେ ରେଡି ଅଛୁ ଆମେ
ଆଜ୍ଞା ରେଡି କୋଣ ହେବେ ଆପଣ ତ ଆଜ୍ଞା ଏକ୍ସପର୍ଟ ରେଡି କୋଣଟା ହେବେ ଆପଣ କୋଣ ସୁଟ୍ ରେ ପାର୍ଟିସିପେଟ କରିଛନ୍ତି so please consider this aspect
ଷ୍ଟେଟମେଣ୍ଟ ଦେଇଛୁ କରିଛୁ ତାର ଗୋଡ
ଆଜ୍ଞା ଗୋଡ ଭାଙ୍ଗିଲେ ଆଜ୍ଞା ଯେପର୍ଯ୍ୟନ୍ତ ମୁଣ୍ଡ ଠିକ ଅଛି ଗୋଡ ଭାଙ୍ଗିଲେ ଅର୍ଡର 9 ରୁଲ୍ 13 କେମିତି ହେଇଯିବ
ସେ
ସେ କଣ କହୁଛନ୍ତି ଆଜ୍ଞା
ଠିକ ଅଛି
at times ଆଜ୍ଞା matrimonial cases are not proceeding in the proper direction it is completely directionless
ଠିକ ଅଛି
left right center କୁଆଡେ ଯାଉଛି ଭଗବାନଙ୍କୁ ଜଣା ଇଭିନ ବର୍ତ୍ତମାନ ବି ଅର୍ଡର 9 ରୁଲ୍ 13 ହେଲେ କେସ୍ ସରିବନି ଆଲାଉ ହେଲେ ଆପଣ ସିଏ ଆସିବେ ନା ଯଦି ଆଇ ହୋପ ମିଷ୍ଟର ପୃଷ୍ଟି ୱିଲ୍ ଆଡଭାଇସ୍ that ରେଷ୍ଟୋର ହେଇଯିବ ଆପଣ ବି ଚେଷ୍ଟା କରନ୍ତୁ ରେଷ୍ଟୋର ହେଇଯାଉ
ରେଷ୍ଟୋର ହେଇଯାଉ ମୋର
Restore हवा से
ଏତିକି କଥା ସେ ବର୍ଷେ ପରେ
ଆଜ୍ଞା ବର୍ଷେ ପରେ ଆପଣ ତ ବିଲକୁଲ ଏକ୍ସପର୍ଟ ଡିଗ୍ରୀରେ ଆପଣ କିନ୍ତୁ ବର୍ଷେ ପରେ କଣ ବୁଝେଇ ହବ ଆପଣ ଦେଖନ୍ତୁ ମୁଁ ବୁଝେଇ ପାରୁନି I consider myself to be a student of law still ମୁଁ ଆପଣଙ୍କୁ ବୁଝେଇ ପାରୁନି ଆପଣ କଣ କରିବେ ଟ୍ରାଏଲ କୋର୍ଟର ଅବସ୍ଥା ବୁଝୁଥିବେ ଅର୍ଡର 9 ରୁଲ୍ 13 ଆଲାଉ ହେଲେ ତାପରେ ଆପଣ ପାର୍ଟିସିପେଟ କରିବେ ଆପଣ ଏବେଠୁ କଲେଣି ବର୍ଷେ ପରେ ଆଜ୍ଞା ଫାଇଲ କରୁଛନ୍ତି ରିକଲ୍ ପାଇଁ କିଛି ଅସୁବିଧା ହବନି ବିକଜ ଇଟ୍ ଇଜ ୟୁର ପିଟିସନ ଆପଣଙ୍କ ପିଟିସନ ଟା ନା ଆଜ୍ଞା ସୋ ସିଏ ତାଙ୍କୁ ରିକଲ୍ କଲେ ଆପଣ ତାଙ୍କୁ ରିକଲ୍ କରୁନାହାନ୍ତି ଚାଲୁ ସିଏ ବି ଗୋଟେ ଚାଲୁ
ତାଙ୍କ ପିଟିସନରେ
ନା ରିକଲ୍ ହେଲେ ଆପଣ ଆପିୟର କରିବେ ଆପଣ ଯାହା କରିବେ କ୍ରସ୍ ଏକ୍ସାମିନ୍ କରିବେ କି ଯାହା କରିବା କଥା କରି ଛାଡ଼ିଦେବେ 20 ରେ ଆଣିବା କି 20 ୱିକରେ ନା 27
27 ରେ ଆସୁ
please consider this now you are both of you are the judges
My lord,
mediators
I have no objection. Allow legal ମୋର କିଛି objection ନାହିଁ
ଦେଖନ୍ତୁ ସେଇଟା ହଉ ଆଉ ଆପଣ ଯଦି ଚାହିଁବେ ମିଷ୍ଟର ପୃଷ୍ଟି ଡୋଣ୍ଟ ହାରାସ ଦ ମାନେ ୱିଟନେସ୍ ଆପଣ ମିନିମମ୍ ଯେତିକି ଏକ୍ସାମିନ୍ କରିବେ ସେତିକି କରନ୍ତୁ
only to
confront two documents
only
I
to
remember ठीक है
only to mark exhibit 2 certified copies
ठीक है आसो rest of the matters after recess
या तो किसी का सचिव ସେଟା ଆପଣଙ୍କର ରିପୋର୍ଟ ବାଜିଥିଲେ ଦେବେ
ସେଥିରେ ଆପଣଙ୍କ ପ୍ରେଜେନ୍ସ ଦରକାର ନାହିଁ you are not required I will record that ଆପଣ only to remain present because it is listed ଆପଣଙ୍କର 3/8 ରେ 10/8 ରେ ଅଛି I have some difficulty forgetting actually so ଆପଣଙ୍କର କଣ how can I mark you as absent when the matter is posted to 10/8
ପକ୍ଷ ତ ଆବସେଣ୍ଟ ରହିଲେ
ନାଇଁ ସିଏ ତ ବର୍ତ୍ତମାନ ଆପଣଙ୍କର ଅଲଗା ଜାଗାକୁ ପଳେଇଲାଣି
ଆପଣ ମାନଙ୍କ ଭିତରେ ଫାଇଟିଂ କିଛି
ଆପଣ ଫାଇଟିଂ କଥା ନାହିଁ ମୁଁ ତ ଫାଇଟ୍ କରିପାରିବି
ଆପଣ ଫାଇଟ୍ କରିବେନି ଆପଣଙ୍କ ଅର୍ଡରକୁ ଜଜ୍ ଫ୍ୟାମିଲି କୋର୍ଟ କେମିତି ମାନିଛନ୍ତି
କଣ ସେ ବୁଝୁଛନ୍ତି କଣ କରୁଛନ୍ତି ସେଟା ବର୍ତ୍ତମାନ ପ୍ରୋବ୍ଲେମ ହେଇଗଲା
ମୋ ପେଜେଟା ନୋଟ ରହିବ
ପ୍ଲିଜ
17ଟା ସେ ଯୋଉ ଆପଣଙ୍କର ଅର୍ଡର ଥିଲା ସେ ଆପିୟର କରୁନାହାନ୍ତି ଆଜି ବି ପ୍ରାୟ ନାହାନ୍ତି ଲାଷ୍ଟ ଅର୍ଡରଟା ଥିଲା ସେଇଟା 17ଟା ପିଟିସନର ସିନ୍ସ 5 to 6 dates
ଆପଣଙ୍କର ପାୱାର ତ ନାହିଁ ସାର୍ ଆଦିରେ
ହଁ ମୋର ଅଛି ନା ମୁଁ ଇଣ୍ଟରଭ୍ୟୁ
ଆଚ୍ଛା ଆପଣ ଇଣ୍ଟରଭେନର ଓହୋ ସରି ଆଇ ଥଟ୍ ମାନେ ଆଇ ଏମ୍ ସରି ମୁଁ ଭାବିଲି ଆପଣ ପିଟିସନର ବୋଲି
ନାଇଁ
ଠିକ ଅଛି ମିଷ୍ଟର ପଟ୍ଟନାୟକ
ସେ ନାଇଁ ଆପଣ ଆସୁନାହାନ୍ତି ତ 5-6ଟା
ଆଚ୍ଛା ଇଏ ଦୁର୍ଗାଚରଣ ମହାନ୍ତି ମାନେ ପିଟିସନର ଆସୁନାହାନ୍ତି କି ଅପୋଜିଟ ପାର୍ଟି ଆସୁନାହାନ୍ତି କିନ୍ତୁ ଇଣ୍ଟରଭେନର ଆସୁଛନ୍ତି ଷ୍ଟିଲ୍ ଇଣ୍ଟରେଷ୍ଟେଡ I'll pass order. I'll mark your pages. No difficulty. But seda padu. Mr. Misra,
Item 20 ଟା ଗୋଟେ miss
you are free. ମାନେ non appearance हमारा नहीं. कि at least जहाँ order करेगा था हम करी. Yes, next.
Item 20 are permitted to withdraw. Interim application has been filed for that.
Okay. That order I'll pass. Yes.
ଆପଣ ଲାଷ୍ଟ ଡେଟ୍ ରେ ଅର୍ଡର କରିଥିଲେ ନ appear
ସେଟା କଣ ତ ଲେଖା ହେଇଛି. ଆପଣ ଯେଟା କହିଲେ it is the matter shall be disposed of ଲେଖା ହେଇଛି. Yes. I understand what you are saying, sir. Yes, ଆପଣଙ୍କର ସାର୍ ଠିକ. Just one second. Pastor, yes.
Pastor, item 13.
Item 37.
37.
Yes. Yeah, I'm the petitioner. Last week I
Other side achoti.
Other side the state is there. Last week
What's adjournment 37 Commissioner Naik.
I want to file rejoinder. Counter I received last week.
Date कर दियो तो खाली. 37 ने date कर दियो.
वो कौन सी 208.
208. Yes.
Item 50.
50.
50. Can be taken on.
50 रे date कर दियो तो.
वो कौन सी 208.
Individual likes and dislikes to be listing. ଆପଣ କହିବେ ବୋଲି ତ ତାପରେ
पेंडिंग रह जाଉଛି ତ ସରି ଗଲେ ଯାଇ
ତାପରେ କୋଦୋଡା ସାର୍ ଙ୍କ ମ୍ୟାଟର ତାପରେ ଆଇଟମ 2 ତାପରେ ସେମିତି ହବନି.
In this case I am for the
No prioritization basis of category of matter. See ଆସି ତ
ଫେସ୍ ଆଡମିଶନ ପଳେଇ ଗଲେ ସରି
କିଛି
ବାକି ଯୋଟେ ଫେସ୍ ଏଡମିଶନ ଛଡା କଣ କି?
ଡିସ୍ପୋଜ ଅଫ ହେଇଗଲେ I am opposite party. ଏ ଟ୍ରାନ୍ସଫର ହେଇଗଲେ ମୋର କିଛି ଅବଜେକ୍ସନ ବି ନାହିଁ.
ବହୁତ ଭଲ କଥା. ଆଜି ଅର୍ଡର ହେଇଗଲା.
ଆଜି
ସ୍ପଷ୍ଟ ଦିଅ ମେମୋ ଦିଅ.
ଦେଇ ଦଉଛି if possible
Hey, don't concede. Concede କରିବା ପାଇଁ ମୁଁ କହୁନି. But the matter can be disposed of at least लिखिକି ଦିଅନ୍ତୁ.
today
आपको मिस्टर गया कोठू कोठी
କଟକରୁ ଜଗତସିଂହପୁର ସିଏ ଅଲରେଡି
ସେଠି ଗୋଟେ
କଟକ ଜଗତସିଂହପୁର ଆପଣ ଜଗତସିଂହପୁର କହିଲେ ବି କିଛି ଅସୁବିଧା ନାହିଁ.
ନା ସିଏ ସେମାନେ
ଫାଇଲ କରିଛି
ସିଏ ଅଲରେଡି ଫାଇଲ one divorce before the London family judge ଜଗତସିଂହପୁର. I also file
ଆପଣ ସାର୍ 24 ରେ ଯୋଉଟା ଟ୍ରାନ୍ସଫର ଚାହୁଁଛନ୍ତି ସେଟା ଜଗତସିଂହପୁର ପଳେଇବ.
ଆଜ୍ଞା
ମୋବିଲାଇଜ
ଗୋଟେ ମେମୋ ଦ ମ୍ୟାଟର 50 ଲେଖନ୍ତୁ. So Karunakar Gaya for the petitioner, Mr. Sujit Kumar Vishwal for the opposite party. The matter is listed for admission for hearing under the list admission for admission. In view of the lack of possibility of the matter being reached during the day's proceeding, it is mentioned by the learned counsel for the parties. Learned counsel appearing for the parties. No. It is submitted by the learned counsel for the opposite party that the court may pass order as deemed fit and proper. Stop. Para. The matter is reserved for judgment.
मेमोटा दे दो हैंड ओवर कर
The memo ta khali just
हां देखो
because I have to make up my mind because I don't want that why he will concede. He's a lawyer, of course.
Matter will be transferred.
But did it?
Minor.
Yes. न पढ़िले एटा ला एडवांटेज है. ये पॉसिबिलिटी था ना अपन जब टोटल 40 था घंटा. Yes. Next. पासवर्ड आके दियंतु.
Pastor, item 14.
14.
Hi.
Non-access for the petitioner. Anyone is present in the hearing? Hybrid mode लिखिए. None appears for the petitioner none. Opposite party blank. None appears for the petitioner, though the matter is called twice over, once when it is, and again upon resumption of the proceeding post lunch. Stop. Earlier the matter was listed before the earlier on 24/3/2026 the matter was listed before the deputy registrar into bracket judicial, law Jiman for removal of the defects pointed by the SR. Thereafter, it was adjourned on 31/3/2026 by order of the coordinate bench, directing the registry to verify, directing the office to verify, if the matter can be converted to WPC as prayed for in an IA at the instance of the petitioner. Thereafter, the matter was had at some length on Sunday, 5/1/2026. The facts of the case in brief as well as the legal issues were noted. Yeah, and noted, and the petitioner had adjournment, and the Lord Counsel for the petitioner had adjournment to address. Stop. Then correct to grant further opportunity to the petitioner, the matter shall be listed for fresh admission in the commencing.
ENIAC. As for item 15. May I please?
Yes, please. Mr. Pratap Chandra Mishra for the petitioner.
Last occasion, we were directed to file some judgment or citation in support of the case. And
which paragraph?
Paragraph 7 of the last order.
Citation to be cited could
Para 6 matter. On being apprised how the withdrawal by the wife can be challenged by the husband in a case of a joint application under section 13B, the Lord Counsel for the petitioner states that he will rely upon certain case law and
yes,
6.
Yes, got it. Yes, please.
And today I'm filing.
Straight away read that. That 13B withdraw consent, it can be challenged. Straight away come to the point so that we save time. Already we are delayed. So the best case you said, only
Best
one case, the
is
best case.
2026 INSC 360.
Yes. Copy ଅଛି ନା ମୁଁ ଦେଖିବି ଏପଟେ।
ଆଜ୍ଞା ମୁଁ ତାର ମାରି ଦେଇଛି ତାର relevant portion which is relevant to this case and which is very much
ଆପଣଙ୍କ ପାଖରେ କପି ଅଛି ନା ନାହିଁ?
ଆଜ୍ଞା
2000 କେତେ କହିଲେ?
2026 INSC 360 report.
13B ରେ consent withdrawal to paragraph.
13B ରେ that is paragraph that is a long judgment. That is para 13 on page 14.
13-14 ରେ ତ କେମିତି ହବନି, conclusion ହିଁ ନାହିଁ। para 13 ରେ ସୁପ୍ରିମ କୋର୍ଟ ର କିଛି ଫାଇଣ୍ଡିଂ ନାହିଁ।
ତାପରେ ଅଛି 42 43 ସବୁ
ସେଇଟା ଏବେ ଯୋଉଟା ବେଷ୍ଟ paragraph ଆପଣଙ୍କ ପାଇଁ according to you which is the best paragraph which says that if the consent is withdrawn then it can be challenged.
That is 43.
Para 43.
No, page 43. Page 43.
Paragraph
47. 47 the continuation है जी. Paragraph 47, page 43.
मैं भूलभाल पढ़ुछन। पेज para 47 रे ଗୋଟେ quotation ହେଇଛି पढ़ो। 47. Because you are struggling with pages and paragraphs, I have to assist you. Para 47 page 42
page ଟା 43 ରେ ଦେଇଛି ତଳେ ଦେଇଛି
अरे सेमती आपण बुझ परना page 43 is a quotation contained in para 47 so you have to read 47 43 is not part of the judgment 43 is part of the quotation ना बुझ परना
ଆଜ୍ଞା
एठू आरंभ हैला 47 एठू कोटेशन हैला आपण कोटेशन को पळेलेनी एठू पढिबे एटा दिस इज द पैराग्राफ ऑफ दिस जजमेंट कोन एते थरो उल्टू चोंदी पेज 42
ଆଜ୍ଞା
47 पढंतु
ଆଜ୍ଞା even recently in the case of Trisha Singh this court was faced with similar situation wherein the wife resigned from
slowly पढिबे so that आपण बुझी परिबे
ଆଜ୍ଞା
why slowly पढंतु तरतरे पढंतु नि so that it registers in your mind
ଆଜ୍ଞା even recently in the case of Trisha Singh this court was faced with a similar situation wherein the wife resigned from the terms of settlement as agreed before the mediator and this court
so here the wife has resigned from the terms agreed before the mediator
not mediator both the petitioner that the present petitioner
that be sir apanor problem helani you are struggling with the first basic mundane fact basic fact ever foundational fact to the court case problem the foundational fact of the case is that a 13B consent after it was given has been withdrawn
without filing
for that you are reading para 47 in your support the para 47 itself states that conditions agreed before the mediator then kindly read further
agreed before the mediator and this court while relying upon Ruchi Agrawal Supra held that such conduct from wife proves that the marriage has been irretrievably broken down and therefore granted divorce under article 142
so then you must realize that this paragraph is against you always try to cite a decision which is in your favor or ete parishrama kariki ote direct decision which is against you why should you file so that I'll dismiss the application
no that is not against and
47 is clearly
the
against
Hon'Ble
you.
Supreme Court has directed for dissolving
You are
of the
arguing in
marriage
Supreme Court or in High Court
this judgment is
you are arguing in Supreme Court or High Court
before your honor High Court
do I have 142.1
no
so you will read many judgments where the Supreme Court has categorically said High Court cannot go beyond the statute cannot pass orders even that has been answered in a constitution bench which is exactly on this point 142.1 granting of divorce because this has been the effort of the this courts have been really making an effort to include irretrievably broken down theory the parliament has not yet amended 13.1 does not have a ground of irretrievably broken down and the Supreme Court has said that the High Court cannot exercise jurisdiction Family Court cannot. So then read further. Then they read Ruchi Agrawal. So Ruchi Agrawal kindly read. फिर कौन उठेले गाड़ी पर ना थी अरे अपन जजमेंट चारधारी पढ़ले तापर छाड़ देले जे
ସେଇଟା the relevant portion from the judgment are reproduced here and under
रुचि अग्रवाल पढ़ंतु तीनटा लाइन छाड़ देले
it is also
this court while relying upon Ruchi Agrawal तापर छाड़ देले
held that such conduct from wife proves that the marriage has been irretrievably broken down and therefore granted divorce under article 142.1 of the Constitution of India the relevant portion
so that 142.1 is not applicable to this court or for that matter family court the relevant portion from the judgment are reproduced here Ruchi Agrawal yes
it is thus manifest that there was a clear undertaking by the parties before the mediator that they shall part ways peacefully.
Yes.
It is also clear that the respondent husband had voluntarily paid a sum of rupees 20 lakh for the support of his child.
छाड़ दियो आपण जोटा हाइलाइट करछन पढंतु para 7 जोटा आपण करि नथल त मु पढै देली आपनको para 7 it seems the petitioner wife having taken advantage of the settlement executed before the mediator. What is the settlement here before the executed either before the mediator or maybe the court? What is the settlement?
Settlement was that is the 13B petition itself that they have all the
13B whether 13B has been can be withdrawn or not this is not a precedence.
After taking
in which decision the petitioners agreed before the mediator for settlement.
Here there is no
Ruchi Agrawal. So Ruchi Agrawal So they agreed. Then after some time before the Supreme Court, they said that we disagree. Our wife has taken advantage and
after taking alimony.
so then 142(1) is exercised. Then what can be done? Can that be applied here in this case?
In this
In
case,
13B. So you have to find out a decision where 13B is there. Any decision on 13B or we are wasting time? Because this is not a debate, sir.
no, I am not.
It can't be a debate. Upon confidently kohle, I have found out a decision. So at least I was happy that I can render a judgment because I can answer that point. Not judgment, a order. I would have issued notice that 13B, even if withdrawn, can be challenged. That was my objective. But now you cite a decision directly against you.
Not the observation that is very quite
Sir,
similar.
You may become Supreme Court, you have the advantage. As a lawyer, you can add any words. I cannot add words to the Supreme Court judgment. For applying, invoking 142(1), I cannot. First point, difficulty. Second difficulty, the facts are completely different. It was sent for mediation, there was agreement. Now you are saying that 13B, if it is withdrawn, it cannot be withdrawn, you can challenge it. But do you remember what I told you?
Published.
What I told you. What you are missing is that there are decisions in this line. This conduct can amount to cruelty also. 13(1) cruelty can be such.
That is a cruelty towards the husband.
I don't know. But upon to add chali gale. Upon वादे कि 142 रे पहुंचे कि mediation भीतर जे कि पहुंच गए. Any decision on where 13B, because Mr. Misra, my effort is that I should give an answer to this problem. This is a continuously misutilized. 13B has been misutilized like this. Your case is genuine. Your case is genuine. So unless I elevate yourself, your research to that level, you cannot answer. You have, in fact, by doing some research you have done, quite extensive also, but that is not on the point. Try to get that, so that I can give a definite finding that 13B can be challenged. Withdrawal of 13B can be challenged. Because I am yet to get at my hand any decision on this.
So 1 week up to this.
And you find in many cases, they are saying that after the negotiation also some money was paid. Now after receiving the money, like Ruchi Agarwal. But Supreme Court, obviously they have 142. I cannot take it that to exception. The choice of a litigant to whether to obey or not obey, whether to be honest with the commitment before the court for agreeing. Court cannot take it personally. Please appreciate that also. I cannot let them do whatever they want. Even if I feel bad, so it be. But Supreme Court has 142(1). 226 power cannot be exercised here. It is only appellate power or revisional power.
After I will appraise by filing another.
Aro dita decision ko point re. Say mediation na nahi 13B re church.
Same mediation.
Mediation
and unilateral withdrawal of the consent. On basing upon that decision, this unilaterally the wife cannot. Because after receiving alimony.
Apanakara 13B re seta anibe na. 13B is a statutory provision. Unless 13B has a proviso, provided that once a consent is given, cannot be withdrawn. Or any case law interpreting that. There you are struggling, also definitely I am struggling. Because you have to educate me. Issue decision, it is not in your favor. It is very clear that, first of all, it was a mediated settlement. The wife resigned from the settlement and Supreme Court exercised 141. The Lord Counsel for the petitioner is hard at length. He refers to the earlier order dated 18/5/2026, particularly paragraph 6, wherein the following was directed. The learned counsel refers to the judgment of the Honorable to answer the learned counsel to answer the legal issue as noted in paragraph 6 above. The learned counsel for the petitioner refers to the judgment of the Honorable Apex Court in Dhananjay Rathi versus Ruchika Rathi. Data bindu dekhi column 2026 INAC 360. Decided on 13/4/2026. Relies on paragraphs 46, 47 of the INSC print. How could I fulfill it? ଏଇଥିରେ ସେମାନେ କଷ୍ଟ କରିଥିଲେ କି 10,000 ଲେଖେ ଇନିସ୍ ଦ ମ୍ୟାଟର 10,000 ଟଙ୍କା ଲେଖେ କଷ୍ଟ କରିଥିଲେ ଜଷ୍ଟିସ ବିନ୍ଦଲ୍ସ ଜଜମେଣ୍ଟ पारा 55 टा देखुनांती देखो
पारा 13 सर
13 टा फाइंडिंग डोंट कंफ्यूज बिटवीन ए प्रोपोजिशन एंड ए फाइंडिंग कमीशन टा 13 ना 55 to direction, these are all 142 one direction. The quote करते हैं 47. Perusal of the judgment in Dhananjay Rathi indicates that the Honorable Apex Court was dealing with a situation where the wife resigned from the terms of settlement as agreed before the mediator. Then, comma, a semicolon. The Honorable Apex Court relied on Ruchi Agarwal. Versus Amit Kumar Agarwal. Colon into bracket 2005 bracket close 3 SCC 299. And exercised its jurisdiction under Article 142 into bracket 1 of the Constitution of India to hold that thus conduct from wife proves that the marriage has been irretrievably broken down and granted divorce. Jyoti apanakara reasonable achhanti husband ki husband or family. They are ready to give substantial, and which even cannot be thought of. After some time 13B proceeds, they demand more and more till it breaks down. This is what you have to now, as a lawyer, you have to handle it. That will help. It is one aspect of matrimonial jurisprudence where 13B has been misutilized and also not achieving its objective. That is how you are important, Mr. Misra. Your research is important. Correct. The learned counsel for the petitioner has adjournment to find out to advance further arguments. The matter shall be listed for fresh admission in the week commencing. Tiniat. Thanks for your time. You have at least contributed and done some research work. I mean, absolutely necessary, of course. It is necessary for you, both for you as a lawyer, and definitely to guide the court. Yes, next.
17.
Petitioner none. Mr. Nayak, Additional Standing Counsel for OP number 1. OP number 1, no? 1, 2, 2, 3. OP 4, 5, none.
Right, 15th time they have not.
Order dated 30/6/2024. Para 1. এটা 500 ভর না serial. Para 2 রে লিখিও none had appeared when the matter was last taken up on. When it was taken up on 4/5/26, 19/3/26, 25/2/26, 22/1/26. Stop. On 7/4/26, the learned counsel for the petitioner, Mr. Devata, had appeared. No, sorry. The learned counsel, the learned advocate on record, Mr. James Patnaik, did not appear. An adjournment was sought for by Mr. Asutosh Devata, learned counsel on his behalf, learned proxy counsel on his behalf, as noted in the said order. Since then, for the last more than 3 months, the matter has been listed on 4/5/2024, 30/6/2024, and no one has appeared on behalf of the petitioner when the matter is taken up. Matter being in the list is taken up. Learned counsel for the petitioner, learned counsel for the interveners reiterates his submissions as noted in earlier orders that though the matter is kept pending for the last 30 years, the petitioner is not taking any steps, rather he has been consistently defaulted in appearing before this court. Considering the submissions of the learned counsel for the intervener, the matter was on considering so and so on 30/6/2024. The matter was directed to be listed today, indicating that it shall be disposed of. It was further directed that copy of the order along with the order dated 36/2026 and order dated 4/5/2024. And it was further directed. Order dated copy of the orders dated 13/30 and 4/5 shall be forwarded to the learned counsel for the petitioner. The registry has communicated the order. Communicated the orders to the learned counsel for the petitioner, which has yielded no result as no one appears for the petitioner today, the matter being listed for orders. In considered view of this court has shown sufficient indulgence to the petitioners, and the writ petition is kept pending since 2013. Kept pending after it was presented before this court on 8/11/2013. In considered view of this court, no purpose should be served in keeping the matter pending. Accordingly, The matter stands dismissed for non-prosecution. Yes.
18.
18, there are two matters.
Yes.
I am in the review petition 243 of 2019.
I am the petitioner in our review petition 407 of 2019. And I have filed this review petition.
Both the parties want review petition.
Yes, ma'am.
Are you a student of law?
No, ma'am.
So how you are confident that you can argue a review application?
I have done some research in this area.
Research. You have studied which why madam is standing behind you. She can have her seat, or she's assisting you.
No, she's
So you ask her to sit. Don't make her stand. It looks odd. So you are a student of what?
in civil engineering, BTech.
BTech civil engineering. You have done research where?
My own research to
Where? What is the material? Google University.
Yes, through search engine. Through search engine.
So which search engine?
Google.
Google. Are you confident you can argue?
Yes, my lord, I am confident.
Which provision review is maintainable?
In which provision? Review petition is basically it is filed.
No, I don't want I am a good speaker. So I don't want a speech. A very specific pointed answer. Which is the under which provision review is maintainable?
It is a civil provision. Review is a civil provision. Civil matter.
Civil provision.
It is
Okay.
civil.
I have to record this. You can't interfere apart from being a civil engineer. You have to know how to behave in a court also. You can't interfere when the court directs something. Order that. Records order. The RBWPT 407 of 2019. The recorded achita. Party na likhibe petitioner in person, opposite party blank. The petitioner appears in person. He submits that he will argue in person the review application. On being asked by the court whether he is a student of law, he submits that he states that he is not a student of law. He is a student of engineering, being a BTech in civil engineering. The petitioner is made aware that law being a subject which requires a lot of reading and understanding, and for a lawyer requires practice to understand the nuances. He responds that he has done some research and he can argue the matter. On being further asked where he has made the research, he submits that he has made the research in the internet through the search engine. To prima facie ensure that the petitioner is capable of understanding the nuances of arguing a review application before High Court, he was asked under which provision review petition is maintainable. He submits that civil provision, apart from giving a general non-specific answer to the concept of review petition. The petitioner is advised to avail legal aid if he is not willing to spend any money for litigating before this court. He has the option of meeting the secretary legal aid for seeking legal for seeking assistance. Now I'll ask you certain questions in civil engineering. You have studied civil engineering by basic construction.
No, in construction completely.
Construction,
all the-
okay. Have you ever designed any roof like this?
My lord, I have designed in StatPro, I have designed a building so that it can be earthquake resistant.
No.
My project.
So that is you have designed a building.
I have not architectural design. I'm not into architecture.
Designed in structural design. Have you
Structural
ever
design.
structurally designed any design?
Structural design. I have
Correct,
done.
correct. So you find out what is the thickness of reinforcement steel.
Yes, in that we directly put the information regarding the length and width of height of an.
So
Automatically it takes,
so what is the for the roof? What is the concept of having a
for the column you have 25 mm of roof you have bar bedding for 8 mm, 15 mm, it depends.
So if you reduce it to 6 mm or 3 mm, can you?
No, we cannot reduce in that.
So I just want a little bit detail. More than that, you might be expecting that I do not understand, but at the cost of being sounding very naive and lack of understanding, how do you consider this roof while designing rod distribution, reinforcement bar distribution, rebar, as you call it, rebar?
Yes. The roof is that is a dead load. That is a dead load on
Dead
the
load.
foundation.
So you divide it into a
That is decided upon the foundation.
four trapeziums.
No, it is not a basically a trapezium because it can be a square, it can be of
Roof is definitely a square, but as far as you design, when you are distributing, calculating load, dead load, you are distributing it in a trapezium.
No, not that way, because it is not a basically not a form of trapezium. We'll be having
Not four trapeziums.
No, it's not basically in that way. Not trapezium. It depends upon the.
So now suppose you are while designing that, you miss to give a rebar. Will the roof stay or collapse?
If I miss to give a rebar, it is not going to collapse.
Not a complete rebar you have missed.
Completely they need to do.
Because Mr. Das now starts constructing. He says that engineering is nothing. Why should I give rebar?
No, it will not stay. Because without rebar, without reinforcement, it won't be staying.
Without reinforcement.
Without
The
reinforcement.
9/11, that World Trade Center was reinforced. So why did it collapse?
But that was impact. That was a sudden explosion. And
Did it collapse after the explosion?
no, after when the fire, due to the fire.
Did it? Check the video. It was sufficient to withstand even that jet explosion did not collapse. Fire did not collapse. It took some time.
Because they have an internal sprinkler system also. It takes time. For still
You check it. The causes you have thought about is not the cause. The cause is that when the upper portion collapsed and the net load came on the roof, it fell down. So if it was standing still, yes.
To the weight.
Because of the weight, when it was standing, the weight was not on the roof. It was distributed.
When it was constant.
Why I am saying this? If like engineering is a concept and technical, if you do not know the provision also. And you have started by reading, researching in that review, you must read law that way, approach law that way. And initially for a science student, it becomes very difficult. I found it very difficult being a science student. After spending some quite substantial time in science, so I found it difficult because at times 2 into 2 equal to 2.4. At times it is 1.8. So my perception of law was, I was really, initially, I could not believe actually. I could not understand that how sometimes it is 2.4, it is sometimes 1.8. Sorry, 2 into 2 plus 2 is 4. It will be 4.2 or 3.8. You cannot achieve 4. So it is basically a lot of reading has to be done. Once you want to argue a review, you must know what you are doing in court. Like you are designing a pillar, you don't design a roof. You have to, it has to be a pillar. And again, rebar do not have. Today your preparation is not having not a single reinforcement bar.
Can I say something?
Please, definitely. But you must understand what you are saying.
Yes, this review is filed after the instructions of the Hon'Ble Supreme Court. The review to be filed before the Hon'Ble
Supreme Court has said that the lawyers will not argue without the provision. like the basics you are lacking, I can find out what you are lacking in your submission. And Supreme Court never said that the review, when the review will be argued, the provision will not be considered. Today, definitely, since you are you are searching a lot in Google, if you ask this question to Google, it will answer. You'll get the provision.
Yes, that is a civil procedure.
But since I find that, you see, it will be a lot of wastage of time. It is not common sense argument that you are so emphatic in speaking and convincing people. So then the best motivators to become lawyers also. They will motivate the judges or the other side. Not to motivate Mr. Das. So you seek legal aid. If you do not want to spend any money, if any money is a constraint for you, then seek legal aid. So that at least the discussion it can be there. And now a review was argued upon audio you have to start. Not a problem. But that requires a lot of study. But basics, you must be knowing that you are arguing if you want this provision of review. What are the points to be argued or considered by the court? So, you are not understood the Supreme Court order. Supreme Court has directed us, Supreme Court has directed.
It is directed to the petitioner. Yes, it is directed that we find no reason. I am the respondent in the same case. I am not a petitioner. We find no reason to entertain the special leave petition, which is accordingly dismissed, pending applications, if any, such and disposed of. However, the petitioner is permitted to avail the remedy of review.
No short-term permission, Supreme Court has granted.
Petitioner has.
So this is how you will understand. Like there is a lot of completely different direction and the permission taken by you. That is this is the problem. You have to use legal language and understand the meaning. What's your problem? Supreme Court has not directly to take this.
Perfect. It's the petitioner of this case.
Whatever.
They have also filed the same review and same problem.
Yes.
243, the same thing.
Recording stopped.
I'm in a lot of difficulty.
Recording in progress.
I'll come to court. I'm in a lot of difficulty. I have not received 13 years maintenance for 13 years. That is not a legal issue to be answered. You have to understand that what you are arguing is your right. You are not seeking any help. You don't have to invoke sympathy. You have to tell that much. that this is my right and I'm entitled for this. For that, you need to understand the law. And that requires study. This can't be amateurish. And Google has a problem of hallucinating in law. Which is why the Google search engine is not working in legal research. They have separate. The reason being it can't understand. But a student of law who has read law, if he suggests the words, like today I asked you, anyone can check it. Just simple. Under which provision review is maintainable? Straight away it will answer. Because that you have not thought about it, and you should not feel bad about it that you could not know. Because you are not required to know actually. Is it required for you to know that under which provision review is maintainable? Not
But I
required.
was bound to come to this part because when the advocates were engaged in this case, they did not conduct the case properly. So the petitioner's mother has suffered a lot of expertise in the previously when the dates were.
So that
called.
passing a comment about the lawyer is your prerogative.
For that,
I cannot take cognizance of that. That is beyond my. I am not sitting here to receive complaints about the conduct of lawyers. Be sure of that. Even if I am addressed my lord and many things, it's little bit larger than life image. But I am not here to judge conduct of lawyers. I can hear and decide review, and it is easy for me to dismiss your review application. But that I will not do. I will wait for an argument worth considering. That is how I recorded whatever I have said, because it has to be transparent also. Your lack of trust in lawyers cannot eliminate the role of a lawyer. Have you ever had a person who has lost the case satisfied with the judge? Never. Rarely they are satisfied with the judge and say that the judge has understood. Rather they say the judge cannot understand anything, he doesn't listen. All these things. But obviously, as a judge, I am not supposed to answer to that. Suppose even if criticized by a person and who is unhappy and he scolds me outside or whatever. So and indirectly you are adding to that. Handling by incompetent lawyers cannot lead to a situation where it will be argued by a person completely lack of knowledge of law without any substance. How you are helping your mother? You are saying that your mother was not helped by the incompetent lawyers, a case being conducted badly. And you are worse. You do not know the provision of review, but you are ready to argue a review.
Regarding the
Please understand that it is like getting treated. At times we say that this is the medicine, that is the medicine. Medication fails many times. But that doesn't mean that medication without medication or applying wrong medication it can work. You are doing that. Even that I can record also. But since you do not understand exactly the ramifications of what you are saying or what is being discussed, I should not record. Even I can record that you are saying that your mother was not properly represented, and still you are worst kind of representing a legal litigation. That you have to be fair to yourself, honest, to evaluate yourself. By saying that lawyers are bad, whether you can do a good job. Yes, anything else?
Regarding the opposite parties, they have filed the same review petition, the same thing they have also followed. So I am the opposite party in that same case.
Correct, but I don't wish that you argue the argument and without any substance,
But
the other side.
As an opposite party, I can have an argument.
No, you must argue you don't have a choice here. You don't have a choice here. You have to argue your petition. Either yourself or through a lawyer. Better you take adjournment and think about it. Because then the only option could be that I have to dismiss your review and hear their review. You will not be benefited by that. If you want that, very well. You want that? The cons would service interest. Secretary HLSA, High Court Legal Services Authority. Then go to Ain Seva Bhavan. And ET officer Chitole. We boson the reason for a Guru Lekotu, the learned counsel for the petitioner appearing in review, the review petitioner appearing person was heard at length, and he was explained the nuances of law. No, not nuances of law. He was explained the requirement of knowledge of law in arguing a review application. He submits that the Supreme Court has, quote, directed for review to be filed by the petitioner, quote ends. Perusal of the judgment, perusal of the order of the Honorable Apex Court, dated 8/4/2019, passed in. ଆପଣ ବି SLP କରିଥିଲେ?
In fact, I had the lack of instruction because of absence of Mr. Santosh Mahanti, my briefing lawyer.
କଣ ଲେଖିଲେ? Passed in SLP number 16459 of 2019, arising out of final judgment and order dated 8/4/2019. In RP FAM number 16 of 2018, passed by this court by a coordinate bench, indicates the following. Indicates that the following order was passed. Quote, we find no reason. A flag last year, flag logai. We find no reason up to making issue before the High Court. Yes. Second matter, RBWPT 243 of 2019. Suryakanta Das for the review petitioner. Of the petitioner, Mr. Opposite party jo lekhibe in person. The learned counsel for the learned counsel for the petitioner seeks that further accommodation to obtain instruction if any SLP was filed by the present review petitioner before the Supreme Court. And accordingly, he has adjourned. Stop para. The opposite party is present in person. He has been explained the requirement of knowledge of law as he appears in person as the review petitioner in the connected RBWPT 407 of 2019. Matters shall be listed for orders in the week commencing. Yes. I got a date in person. How much time will require to make up your mind?
Next.
Take 2 weeks time.
2 weeks.
And better you concentrate on civil engineering, will be asset to the nation. Leave this part. Because if today I blame the civil engineer who has constructed that World Trade Center, it will be wrong. No building can be designed for crash of a full-fledged jet with full load of fuel. Can you design that? Perhaps it is more powerful than the bunker buster bomb. Obviously, at least thanks to him that he's designed it and it stood tall. Till obviously upper person collapsed and the entire thing collapsed. So even if lawyers are bad or you had a bad experience with lawyers, but that doesn't mean that you on your own you'll spoil the matter. At least have some trust in the system Correct. You went to Supreme Court.
No, we do not go to Supreme Court.
You are.
I am the respondent.
Acha, acha.
Supreme Court is
Well,
only they have gone.
Well, the order is incorrect. Just now you see that I have committed a mistake.
Yes.
Simple mistake of not realizing who is the. And please mark Mr. Das. He took me seriously. He said that I'll obtain instruction. कौन लिखे ना? नहीं, okay, second matter. नहीं, सेटा काटी दे. Seटा काटी. When counsel for the petitioner submits that the petitioner challenged the judgment order dated ete. Seटा ठीक है. Order dated ete in RPFM number ete. By filing SLP number ete. In the said SLP, the following order was passed. Quote kar dele. Para. He submits that in view of the leave granted by the apex court, the present RBWPT is filed. आपण देखिए, the matter shall be listed. नहीं, से तापन appearance अच्छी है तो. The opposite party appears in person. हाँ, explain है गला in the connected. तापन लिखो तो date कर दियो. The matter shall be listed for orders or
5 से 8.
5 से 8 होगा ना ने आगुरु.
No.
और 5 से 8 आसु. Then Mr. Das.
Yes, sir.
Now he cannot answer that question. This question I asked to Mr. Das, actually it is a pertinent question.
Madam, can I say something? When they filed the same reputation, the same thing, that is also of the same level of incorrect ground. Was if it is civil procedure, they have also the same.
No, you have not read that. What you are talking is with greatest of if you permit with your permission. Had never challenged the order passed by this court in RPFM 8/4/2019. Order dated 8/4/2019 passed in RPFM number 16/2018. The review petitioner, though was arrayed as opposite party, was respondent in the SLP. The SLP was dismissed at the stage of fresh admission without issuing notice, and the order was passed, granting liberty to the SLP petitioner, that is the present opposite party, to avail remedy of review before the High Court. The review petitioner shall also answer whether, after the SLP having been dismissed by the Honorable Apex Court, SLP at the instance of the opposite party having been dismissed by the Apex Court, without the review petitioner assailing the original order in SLP, review would not be maintainable. As the SLP was dismissed on merits. Very difficult to understand. Every word is difficult to understand what I have dictated. But the problem is that it has to be done. you have a Supreme Court order staring at you. Must understand that. Yes, next.
19.
Petitioner
See, my lord, I am in this
standing counsel for the
my lord, the last order, my lord, last order dated 1/5/26. May I place, my lord?
Mr. Ajit Kumar Hota for the petitioner.
My lord.
Mr. Nayak, AC for the OP number 128. SK Patra for OP 9.
My lord.
Last occasion, Lordship has directed to us.
Soft copy. Denanti.
Copy to.
Deleni apanku.
Copy.
My lord, it was registry to give, my lord. My lord directed to collect the copies from the registry.
ସେ ଦେବାକୁ ମନା କଲେ ଅଛି ନେବେ ଆଉ ଯାହା ଦେବେନି
ମାନେ ଅଫିସରୁ ନେବେନି ସେମାନେ ରେଜିଷ୍ଟ୍ରିରୁ ନେବେ My lord has already
ରେଜିଷ୍ଟ୍ରି କିଛି ଦବା ନବା କରୁନାହାନ୍ତି ଆଜ୍ଞା ସିଏ ତାଙ୍କର ରିଭ୍ୟୁ ଆର୍ଗ୍ୟୁ କଲେ ଆପଣ ସେମିତି କହିଲେ
Individual capacity is left. Yes, sir.
ନବାକୁ ପଡିବ ନା ରେଜିଷ୍ଟ୍ରି ଦବ କାହାକୁ ଦେଇ submitted by the learned standing counsel submits that he shall obtain copy of the he has not obtained copy of the petition along with other papers from the registry and seeks adjournment. Sentence after ପଢନ୍ତୁ standing counsel appeared to OP 9 copy. That both standing counsel. Upon the designated standing counsel level.
Yeah.
That already he has not. From the registry as observed by order dated 1/5/2026 and 6 further adjournment. He shall obtain कितने दिन नेबे 5 days.
5 days.
He shall obtain the copies within 5 working days and seek and obtain instruction. Mr. Naik, आपन instruction?
In their application, they have already received. The claim of the petitioner is that. On
What a counter file करना Mr. Datta has been mentioning this.
We have filed counter.
File?
No, not filed. We have filed. All
So explain करो.
I am there. As we have identified.
CPO is there, GPO is there, CPO is there, everything is there. Agreement to.
We have everything has already received. Counter we have explained. Everything.
The learned counsel for the learned assistant standing counsel submits that he shall file his response.
Right.
But the learned counsel for the petitioner objects the prayer for adjournment and submits that the matter is kept pending since 2022. Stop. To grant further opportunity to the opposite parties, the matter shall be listed for orders in the week commencing. Mr. Hota ko Mr. Hota raguchandi. Kebe asle habo?
2-3 weeks ଦେଇଦିଅନ୍ତୁ ଆଉ 2-3 weeks may be required.
3 weeks. Because what sound hoch.
My date be fixed.
Ajhe 14. Shall be commencing 3-8 ठीक 3-8 रखନ୍ତୁ.
मैंने डेट भी फिक्स
सर डेट फिक्स कले काली सर कोर्ट हेलान ना नहीं आज इट नॉट बेनिफिटेड यू बुझिवा दरकार है
आई एग्री
अगेन डेट फिक्स कले से कोन करिवे लिस्ट कर परिवे हमर रजिस्ट्री ना कोर्ट मास्टर बिकॉज़ इट इज वीकली सो इट इज ए वीकली लिस्ट एक्चुअली
मैंने व्हिच वीक मिला
सर 3-8 वीक रे आसीबो
3
eso होते हैं
इतने आज बॉडी की 55 हे गला फेरे तो लिमिट भी करिला नहीं कोन करा जो Yes, next.
Item 20.
Mr. Tushar Kumar Mishra for the petitioner. Yun. It's a I attach. The matter being listed for orders is mentioned by the learned counsel for the petitioner at the beginning of the day's proceeding. Learned counsel refers to the IA number 266 of 2026, wherein the following prayer has been made. Hello. Prior to the matter being listed today, it was earlier listed on 22/6/26, 6/7/26. And the following orders were passed. In view of the prayer made in the IA, the revision application is disposed of. The IA is also disposed of. The revision applications along with the IAs or interim applications stand disposed of. IA number 266 of 2026 is disposed of. Okay. Next.
Item 21.
Mr. S.S. Ponda for the petitioner. The कौन है mention? अच्छा এটা मैं file करिए आप ठीक है. The Lorded Council, the matter is listed for orders. It is submitted by the Lorded Council for the petitioner that the petitioner shall take fresh steps for filing of requisites in the discovered present correct address. Accordingly, for the 7 days time is allowed, is granted. Accordingly, it is directed the requisites, the requisites in the present correct address be furnished within 7 working days. RPFN. So, the interim order dictator. कौन से से complete करना shall be filed within 7 working days. तापर लिखिए the unutilized copies of the postal requisites, if any, shall be utilized. है तापर लिखिए the Lorded Council for the petitioner prays for interim order to be extended. Stop. Accordingly, the interim order dictate dictate. देखो 11/5/2026 is reiterated. तो जो अच्छी paragraph 10 रे अच्छी repeat ହେଇଗଲା. Date ଟା ଦେବେ shall be adjourned beyond 24/8.
Adjourned beyond 31/8. 24/8.
24/8 ଆସିବ. ମୁଁ ଭୁଲ ଲେଖିଛି. Adjourned beyond 31/8. The matter shall be listed in the week commencing 24/7.
24/8.
24/8/20. अच्छा এটা হচ্ছে 7. The matter shall be listed in for orders in the week commencing 24/8. Interim order টা beyond 31/8. Yes, next.
Item 23.
Date कर दूं. Is Tapaswini Sinha your matter? अच्छा, this is the matter is listed today for consideration of the response of the registry to order number 6 dated 8/7/2026. You take your seat. Petitioner blank, opposite party blank. Who order টা লিখলে? Response of the registry. Okay. On 872026, the following order was passed. ହେଲା? The report of registry in response to the order number 5 dated 872026, paragraph dash is to the following effect. Report of the registry in response to the order dated 872026, paragraph dash has been placed on record marked as flag R. Full stop. Relevant portion of the order, the relevant portion of the report is indicated here. In obedience to the kind direction of the Honorable Court, it's had there. The matter shall be listed for order number 5 लिख लेता will be listed for orders in the week commencing 17/8/2026 as directed earlier by order number 6 dated 8/7/2026. Report of court करो end of damage agreement. Yes, next.
24.
So Vikram Kishori Mohanty for the petitioner.
To take some instruction regarding the area payments. Some adjournment once.
ଆପଣଙ୍କ ନାଁ ଆଜ୍ଞା?
My lord, I am for the respondent.
ମହାପାତ୍ର?
No, Sushant Mahanti. Sushant
So SK Mohanty for the opposite party. The learned counsel for the petitioner, referring to the order dated 23/2/2026, submits that he requires further time to obtain instruction and file. Obtain instruction.
Yes, ma'am.
Stop. Para. Adjournment is granted reluctantly. The matter shall be listed for orders in the week commencing 10/8/20 listed for orders in the week commencing 10/8. ଆପଣ ଏଟା କଣ execution ନା କଣ ପେ? Are you paying? ପାଉନାହାନ୍ତି କିଛି?
ନାଇଁ ଭାଇ।
Do something.
କେତେ ଏରିଆ ଅଛି ଟିକେ ତାର କେତେ
ଆଉ ଦିଅନ୍ତୁ ମିଷ୍ଟର ମହାନ୍ତି।
ଦେଖିଏ ସାର୍ ମୁଁ ନେକ୍ସଟ ଡେଟ୍
next date ରେ ଦେଇଦେବେ।
ଆଜ୍ଞା।
Yes, next.
25.
Sir, M.R. Mahapatra for the petitioner. Mr. Upendra Kumar Samal for the petitioner, along with Mr. M.R. Mahapatra, Mr. A. Patnaik for the opposite party. Yes, Mr. Patnaik.
Pursuant to your lordship's query, I have filed an affidavit stating the income of the husband. That is
flag A.
Flag A.
So Patnaik.
My lord.
Achi.
I have
affidavit achi.
My lord, in the petition and before the trial court, my lord, the wife has stated that the income of the husband is 1,20,000.
Yes.
But thereafter, subsequently, in additional
affidavit achi na nahi.
ଆଜ୍ଞା।
ଆଜି ଆପଣ ଥିଲେ କି ସେ ଯୋଉ ଆର୍ଗ୍ୟୁ କରୁଥିଲେ ରିଭ୍ୟୁ ସେତେବେଳେ ଥିଲେ କି?
ନାଇଁ।
ଆରେ ଗୋଟେ ଜିନିଷ ସରୁ ଆଗ ଆପଣ ଯଦି କହିଲେ ଆପଣଙ୍କ ଆଫିଡେଭିଟ୍ ନାହିଁ ତାହେଲେ ଏପଟେ ଦେଖନ୍ତୁ ମିଷ୍ଟର ମହାପାତ୍ର ଆପଣ ଏପଟକୁ ପଳେଇ ଆସନ୍ତୁ ତାକୁ ଛାଡି ଦିଅ। এইটা ହେଲା ପରେ ଏଇ ଅସୁବିଧାଟା ହେଇଛି ଯେ ଆପଣ ନାହିଁ ବୋଲି କହିପାରିବେନି କାରଣ ଆପଣ ଦିଆ ହେଲା ଦେଖନ୍ତୁ।
ହଁ ଆଜ୍ଞା
ଦିଆଯାଇଛି ଠିକ ଅଛି ଆହୁରି ଭଲ ବର୍ତ୍ତମାନ affidavit ରେ କୋଉ portion ରେ ଆପଣ କଣ କହୁଛନ୍ତି କୁହନ୍ତୁ I got your point.
ମୋ କହିବା କଥା ଆଜ୍ଞା petition ରେ
1,20,000 କହିଲେ
କହିଲେ ପୁଣି ଏଥିରେ ପୁଣି affidavit ରେ 70 କୋଉଟା ଠିକ?
ଏଇଟା ନେଟ୍
ନାଇଁ ନାଇଁ ମୁଁ ନାଇଁ ନାଇଁ
ସହଜ ହେଇଗଲା I can easily answer. It is a question is asked by the learned counsel.
ନାଇଁ ନାଇଁ sorry
Patnaik.
sorry
For
madam
the
sorry
ସେଟା ବି record କରିଦେବି.
ନାଇଁ sorry
After asking the question, the learned counsel begs sorry. But since the question is very easy to answer, this court prefers to answer the question. It is not difficult, sir. If you keep it simple and straight, always.
ତାପରେ ଆଜ୍ଞା ଆଉ ସେକେଣ୍ଡ ପଏଣ୍ଟ ଇଜ ଦ ପିଟିସନର ସରି
ଆପଣ ଆଜି କଣ ତାଙ୍କୁ ମିଷ୍ଟର ମହାପାତ୍ର ଆପଣ ଜଳଖିଆ ଫଳଖିଆ ଦେଇଛନ୍ତି କି ତାଙ୍କ ଫେଭରରେ କାହିଁ ଆର୍ଗୁମେଣ୍ଟ କରୁଛନ୍ତି ଆପଣ କେମିତି ଜାଣିଲେ ଯେ ଏ କେସଟା ରିମାଣ୍ଡ ହେବାକୁ ଅଛି ବୋଲି ଏଇ ପ୍ରୋବ୍ଲେମ ପାଇଁ you are adding fuel to the I was ready to say এটা ଆପଣଙ୍କ ଏଠି ସମାଧାନ ହେଇପାରିବନି it has to be remanded because both parties are not agreeing for the amount ଆପଣ agree କରିଗଲେ settle ହେଇଗଲା ବର୍ତ୍ତମାନ income is the issue question to be answered. This court cannot answer the question. That I was saying that it is easy. This is not a trial court. And revision, the principle is that I cannot re-evaluate the evidence. Hi, achi seti. Kepe appear karibe kuntu.
ଆଜି ଲଢଛି
ସେଟା ତ ନାହିଁ କହିଲେଣି ବହୁତ ଥର ସେ ଜାଗା ହବନି ଡେଟ୍ କହିଲେ କ୍ୟାଲେଣ୍ଡରରେ କହିବାକୁ ପଡିବ ଆଜି ଲର୍ଡସିପ ପ୍ଲିଜେସ୍
ଅଗଷ୍ଟ 5 ତାରିଖ
ଠିକ ଅଛି ଠିକ ଅଛି Mr. Upendra Kumar Sam, it is the learned counsel for the parties who had further. The learned counsel for the petitioner reiterated his submissions that para 3 order dated 752026. Mr. Shedaran, reiterated his submissions that I'm dictating that the opposite party husband in the marriage earns an amount which would be evident from the affidavit filed by the petitioner wife enclosing enclosure kete seta
ସେଟା ବେସିକଟା ଦେଇଛନ୍ତି 67,160 and net is
Annexure 4
page 19
Annexure 4 page 19
Satyabrata Pradhan serving at scale 2 branch manager Sonpur
I'm not getting it
page 19
page
19 of my affidavit
this is RPFN kete
Annexure 4 टा है affidavit रे
260 अच्छा Annexure 4 at page 19
page 19
he submitted in response the learned counsel for the opposite party submits that the stand of the petitioner wife was is that the stand of the petitioner wife before the learned judge family court in the proceeding was that the husband earns kete कहले आपण Mr. Patnaik 70,000 लाख 20,000 से कोन कॉन्ट्रैक्टर आपण क्लाइंट ना कोन
नाही बेमगेस त्रिपाठी
क्लाइंट को बेमगेस त्रिपाठी जेंती मो
ब्रांच मैनेजर
हुकुम सत्यव्रत प्रधान
ब्रांच मैनेजर इंडियन पोस्ट बैंक
कोन लिखे लाख 20,000 stop it is submitted that the present affidavit indicates the salary to be the present the affidavit filed by the the affidavit filed by the petitioner wife relies upon a document which shows the basic salary to be
67,160
the salary to be 67,160 and it is accordingly it is submitted that there is a variance in stand taken by the petitioner wife The summary learned counsel for the petitioner submits that the annexure 4, part of which is referred to by the learned counsel for the opposite party, indicates the basic salary without the further additions and emoluments. Stop.
And in the, sorry, one sentence more, if I put. In the meantime, it has also gone a revision.
And revision complete. Emoluments, out of
and in the meantime, it has already
additions, emoluments and revision. Right. Having heard the learned counsel for the petitioner and the learned counsel for the opposite party, considering the material on record, this court is of the considered view that the matter should be reheard by the learned judge, family court, so and so, for which the matter is remanded. The parties shall have the opportunity of adducing evidence. That is, the present petitioner, being the wife, shall have the opportunity to satisfy the court by producing evidence regarding income of the opposite party husband. Stop. The opposite party husband shall have the opportunity to adduce evidence to support his contention before the learned judge, family court. Stop. The parties shall appear before the learned judge, family court on 4 तारीख 5/8/2026. On the said date, the learned judge so and so court shall pass appropriate order fixing date of next date of hearing. The parties are directed to cooperate in the proceeding for expeditious disposal. So, the petition is disposed of accordingly with the apposite observations and direction.
After limit may be fixed, otherwise it will be delayed.
No, it will
within
not
a
be
period of 6 months.
ଆପଣ ଏବେ କଣ୍ଟିନ୍ୟୁ କରୁଛନ୍ତି ଦଉଛନ୍ତି the stand of the opposite party husband is very bona fide, as he has been continuing to pay the amount directed by the learned judge, family court, so and so. He shall continue to pay the said amount without prejudice to his rights and contentions in the pending, in the revived proceeding or in the restored proceeding. Yes, next.
Within a time stipulated.
Time, there is a Supreme Court very language is that the High Court is doing every day what he should not do.
They are sending the money through money order. Sometimes it is returned. In the last occasion, I have submitted your lordship. They may send the same through UPI. Through UPI number.
Phone pay those.
Which are last? Last order.
order ଥିଲା ଗୋଟେ ଭିତରେ
ଗୋଟେ last order ହେଇଥିଲା.
para 4 of order date 7/5 সেটা লিখিবে এটা ଗୋଟେ লাইন add କରିଦିଅନ୍ତୁ. The opposite party shall pay the amount of ₹7,000 per month directed to be paid as maintenance through UPI oblique any online method like IMPS to the bank. Oblique through the bank.
Some area have not been paid.
ଦେଖନ୍ତୁ ସେ ଭଲ ଲୋକ ଏତେ ନୁହନ୍ତି. ସେ ଯାହା ବି ଭଲ ଥିଲେ ଆହୁରି ଭଲ ହେଇଗଲେ ମିଷ୍ଟର ପଟ୍ଟନାୟକ ତାଙ୍କର କାଉନସିଲ ହେଲା ପରେ.
ପଟ୍ଟନାୟକ ହେଇଥିଲେ ଭଲ ହେଇଥାନ୍ତା.
ସେଠି ଅନ୍ୟ ଜଣେ ଓକିଲ ଥିବେ ସେଠି ଆପଣ ସେ ଯିବେ ସେ ଆଉ ଯାଉନାହାନ୍ତି. ତାଙ୍କର ତ ଏଠି ହାଇକୋର୍ଟ କେସ୍ ସାରି ପାରୁନାହାନ୍ତି ସେ କଣ କରିବେ. Yes, next.
26.
ସେଟା appear କରୁନାହାନ୍ତି. ଆପଣଙ୍କର 26 you are for
Savitri Bal.
where is Mr. Bhuya? କିଏ ଅଛନ୍ତି? ହାଇବ୍ରିଡ ମୋଡ ଲେଖିବେ the petitioner name ଆପଣଙ୍କ ନାଁ?
Sir, my name is Namrata Karo.
Ms. Namrata Karo on behalf of PC Acharya for the opposite
Yes.
party.
Yes, sir.
The matter is listed for orders based for orders. The matter, the non-appears for the petitioner when the matter is called. It shall be listed for orders in the week commencing 10/8. Yes, next.
27.
Yes, may I please, my lord?
Yes.
In persons of 8/7/2026 order, I filed the memo in one page, and that is in flag C. As your lordship has ordered me to file a memo, so I filed it regarding the payments deposited in the court and also the case payment made to the petitioner wife. That has been total about 4,85,000.
So thank you for converting 55 pages into one paragraph. Rather, 4 lines.
Sir, that is the total amount we have paid is 4,85,690.
So you keep on ଆପଣଙ୍କର ଏବେ କେତେ ଦଉଛନ୍ତି କେବେ ମାସକୁ କେତେ ଦଉଛନ୍ତି?
ମାସକୁ my lord 50,000 has been ordered.
ଆପଣ କେତେ କହୁଛନ୍ତି ବା କେତେ ଦଉଛନ୍ତି ନା ଦଉନାହାନ୍ତି କଣ ହେଇଛି?
ଆମେ ତ ଯେତେବେଳେ ଯୋଉଟା ଦରକାର ମାନେ ଡିଫରେଣ୍ଟ ଟାଇମ ରେ ଦଉଛୁ my lord. ଆଉ total
ଡିଫରେଣ୍ଟ ଟାଇମ ନ କରିକି ମାସକୁ ଥରେ ଲେଖାଏଁ କରନ୍ତୁ.
That is very high, my lord. That's why we are not.
ଆପଣଙ୍କର ଭେରି ହାଇ ବୋଲି କହୁଛନ୍ତି ବୋଲି ଦଉନାହାନ୍ତି ବୋଲି ଆପଣ ପଚରା ହଉଛି କେତେ ଦଉଛନ୍ତି ବା ଦେବେ ନା କଣ ସେଟା?
50,000 ଦଉଛି my lord per month.
50 ନା 50 ନା 15?
ମାନେ petitioner 1 and 2 to 25,000, 50,000 is ordered. But I am not even an income tax SSC. I am earning in my affidavit in the lower court. I have said that I am earning only on the house rent of 20,000 per month.
Mr. Boond, court has to believe you. Court goes by the evidence.
Yes, my lord.
So whatever you are saying is not there is no.
Petitioner also has not filed any proof of my evidence of my income in the lower court. Only the statement in.
Sir, that stage has not come. I have not rehearing.
Yes. So, that's why I am not citing all.
You have lost in the trial court. You have not been able to convince the trial court. That is how you are before this court. I am not rehearing now. I have to issue notice.
No, my lord, but the amount is too high for me.
ଆପଣ କେତେ ଲେଖା ଇନଷ୍ଟ୍ରକ୍ସନ ଆଣିଛନ୍ତି ଦବା ପାଇଁ? 25 ଜାଗାରେ
25 half कर दिया जो my lord, I can pay.
ମାନେ ଟୋଟାଲ 25 ଦେବା ପାଇଁ କହୁଛନ୍ତି?
ହଁ my lord.
ଆପଣ 15 30 ଦିଅନ୍ତୁ.
Okay, all right my lord, I will give. 30 fix kale I can pay in each month and issue notice and consider the matter in the.
But the area calculate him.
Yeah, area is, that is why I am saying the area is too high. Because now 10 lakh total, I have given 4,85,000.
ତାହେଲେ 6 ଲକ୍ଷ ହେଲା. 6 ଲକ୍ଷ କେମିତି ଦେବେ?
My lord, if it is counted on the basis of 30,000, in that case.
ମୁଁ ଆଜ୍ଞା କଣ ଆପଣଙ୍କର ଏଜେଣ୍ଟ ନା କଣ କାଉଣ୍ଟ କରି ପକେଇବି ସାଙ୍ଗେ ସାଙ୍ଗେ? ଆପଣ ଯୋଉ ଏରିୟର ଅଛି 6 ଲକ୍ଷ ଟଙ୍କା 6 ଲକ୍ଷ ଟଙ୍କା ଏରିୟର ଦେବେ ଇନଷ୍ଟଲମେଣ୍ଟ ଫିକ୍ସ କରିଦେବି.
Installment
15,000 ଟଙ୍କା ଆପଣ ଦେବେ
per month.
ହଁ 30 15 30 ଦେବେ ଏରିୟର ବାବଦରେ କେତେ ଦେବେ? 6 ଲକ୍ଷ ଟଙ୍କା
ଏରିୟର ବାବଦରେ 20 ଦେବି my lord per month.
25
20 ଦେଇଦେବି.
ନାଇଁ ଆପଣ 20 ଦେଲେ ସୁଝି ପାରିବେନି. ଆପଣ 6 ଲକ୍ଷ ଟଙ୍କା ଆପଣଙ୍କର ବାକି ହେଲାଣି ବର୍ତ୍ତମାନ.
25 ବି ଦେଇପାରିବି my lord. 25 କରନ୍ତୁ. But I am ready to pay the educational expenses of the petitioner number 2, my lord.
Who has restrained you?
Not objecting.
Who has restrained you from paying the educational expenses?
Yes.
Who has restrained you from paying the educational expenses?
That should be adjusted in my payment.
No.
Because the educational expenses itself is too high.
You have started arguing the imagination of the petitioner. You are a lawyer. Don't argue the imagination of the petitioner.
My lord,
it is not a place for imagination of the petitioner. You have to argue substance and law.
Sorry, my lord, I am not saying that. I am saying
who has prevented you from bearing the educational expenses of your son?
that
Aji
itself
Saji, the court has prevented you.
my lord, that itself is quite high. I am keeping him in a boarding school, and I am paying for that.
Whatever, sir, whatever you go on paying. So, ଆପଣ ତ କହିଲେ କମେଇବା ପାଇଁ କମାଗଲା that much. ତା ସାଙ୍ଗରେ other further supervening condition ମୁଁ education ପାଇଁ ଦେବିନି, ଇଆଡେ ଦେବି, ଖାଇବା ପାଇଁ ଦେବିନି, ଲୁଗା ପାଇଁ ଦେବି.
I'm not saying. I'm not saying if it is
convert our conversation to a common room like you are discussing with your client.
My lord, 25,000.
Whenever you are entering the virtual court, leave the discussion behind. Straight away common law.
My lord, your lord fixed that arrear amount of 25,000 I will pay per month.
25 এটা দিয়ন্তু ଆପଣଙ୍କର 30 55 ଲେখା ଦେଇ ଚାଲନ୍ତୁ.
Okay. All right, my lord. I have no objection for
The
that.
order dated
My lord?
ଆପଣ ସେଟାକୁ executing court ରେ deposit କରିବେ 55.
ହଁ.
Pursuant to the order dated एमती लिखंतु Mr. R.K. Moon for the petitioner, the learned counsel for the petitioner being present at virtual court High Court of Orissa at Kalahandi addresses argument on 872026 after considering the hearing considering the submissions of the learned counsel for the petitioner and the affidavit filed on behalf of the petitioner dated 23/26 the following order was passed. Para 2, 3, 2 and 3. It is submitted by the learned counsel for the petitioner that he has filed memo in response to the said order dated 8/26.
Yes, ma'am.
Thankfully, the memo rounds into 7 lines and it captures the entire details of the payments made, such as payments made stop. The petitioner has stated this should have been filed signed by the petitioner. Never take the responsibility of a client. The affidavit, no, why is not signing? The memo has been signed by the learned counsel for the petitioner, indicating that starting with 19/4/2024 up to 1/5/2026, the amount of rupees 4,85,690 has been paid to the opposite parties, wife in the marriage and the son born from the wedlock. Repeat करिए. Order dated 23/4/26 para 2. By order dated 23/4/26, after hearing the learned counsel for the petitioner, the following was directed. They said para issue notice to the opposite parties along with this order, subject to. ଆପଣଙ୍କର ଯୋଉ ଦେଇଛନ୍ତି ଲାଷ୍ଟ କେବେ ଦେଇଥିଲେ?
1/5/2026 ରେ sir.
1/6 ରେ 1/7 ରେ କିଛି ଦେଇନାହାନ୍ତି?
The father of the
petitioner depositing.
Father of the
rupees एंती लिखंतु. Depositing rupees से अमाउंट केते आउथरे मिस्टर मून कहबे जोटा आपण सर कहउथिली 55 right 30 plus 25 amount of rupees 25,000 towards the remaining arrears of about rupees towards कौन लिखिले rupees 25,000 per month towards the arrears amounting to about rupees 6 lakhs and rupees 15,000 ଆପଣ ଯୋଉ 15 ଅଲଗା ନା ଏକାଠି ଦଉଛନ୍ତି?
ଏକାଠି ଦଉଛୁ.
ଆଚ୍ଛା rupees 30,000 towards maintenance of the opposite party number 1 wife in the marriage and OP number 2 minor son before the learned executing court, that is so and so, so and so, in execution case number dash arising out of criminal proceeding number 29 of 2024, decided by judgment dated 25/8/2025. है ना? तो अपन तापर लिखिए upon deposit of the amount, the evidence of such deposit, like order passed by the learned judge, order passed by the learned executing court, shall be filed supported by memo before this court. Stop. Requisites for issuance of notice by speed post with registration and proof of delivery shall be filed within 5 working days. ହେଲା? जो सेंटेंस कंप्लीट है स्टार्टिंग विथ 19/4/24 टू 4,85,690 लिखा है। हाँ लिखा है, ठीक है। तापर लिखिए आउट लिखिए द along with the copy of the writ petition, the petitioner shall file copy of the affidavit in compliance and memo dated 13/7/2026 for issuance of notice to the opposite parties. Returnable date be fixed to 17/8/2026. The matter shall be listed for orders in the week commencing 24/8/2026. आइए 150 of 2026, hard learned counsel for the petitioner issue notice as above along with the petition. Accept one set of process fee as well as postal requisites. The returnable date as well as the next date of hearing shall be as indicated above. In the interim, it is directed that the execution case court election जाएगा number किसी अच्छी
Execution case number 64/25.
court लिख ले the execution case 64 of 2005
25.
Execution proceeding with a CRL.P. number 64 of 2025 under section 147 of BNSS 2023 shall be adjourned to a date beyond 31/8/2026 as would be convenient to the learned court in session of the matter. The learned court shall also intimate this court regarding compliance of the above order regarding deposit of rupees 25,000 towards arrear and 30,000 towards maintenance, starting with effect from May जाए दीचंती पैसा
हाँ मैं जाए दीचु तार बापा मरी गला सर ऑपोजिट पार्टी रो पिटिशनर हस्बैंड रो
केरा कोन प्रोविजन अछि 147 प्रोविजन अछि ना कोन
informing that's why it was adjourned.
सेटिफाई केते माने सेटा कोन तार रिलेवेंस कोन अछि आगे हमें that is the difference between a common discussion and ये
it is a circumstance for which I could not
circumstances आगे अलगा circumstances आपण को आरो लेडी पे फाइल करिवे आपर देखिवे डीवी
ठीक है
आपण को 120 पे फाइल करिन और डीवी फाइल करिवे डोमेस्टिक वायलेंस से फाइनेंशियल असिस्टेंस पे कोन लिखले starting with एक पांच देख ले starting from the month of starting with effect from June 2026, that is 15 June 2026 15 July 2026 15 तापर लिखते हैं 16 14 अगस्त के 14 August 2026 the amount remaining unpaid for June and July 2026 by the petitioner shall be satisfied by making deposits by 28 August 2026. Yes. Yes, next. Urgent certified copy as per we issued as per. Yes.
28.
My lord,
Mr. Ajay Kumar Rai, Senior Panel Counsel for the Appellate.
as per the order dated 14/5/2000.
Requisite Heini.
Within 3 working days.
The Senior Panel Counsel submits that due to inadvertence, the notices on limitation issued by order dated dash could not be filed.
14/5/2002.
14/5/2026. This seeks for the time to file the requisites. Accordingly, the requisites shall be filed within 3 working days. On filing of the requisites, notices shall be issued to the opposite parties, fixing returnable date to
17/8.
date to 17/8 returnable date 14/8 17 कर देना 17/8/2026. The matter shall be listed for orders in the week commencing 24/8/2026. Yes. Next.
29.
And in this case, my learned senior Sumit Mishra has engaged in this case. And the notice from to opposite 3 to 5 has been delivered.
Delivery and sufficiency are different. We had grappled that with in one case. We tried to solve it actually. We tried that it is delivery is sufficient. But the postal department gave us a report that we cannot see. And they have a reason. They said that the delivery point may have the information. Issuing point does not have any record to that. And in that case, what happened? The person, it's a matrimonial matter. The lady said that I never received and she filed affidavit. Then Order 9 Rule 13 was dismissed. That came to High Court. And this goes on actually. In case of no insufficiency, Mr. Mishra, you are appearing for other OPs.
OP2.
I am appearing for OP6.
Awaiting appearance, it has to wait actually. This is item. Mr. Prabin Das is not appearing. You are appearing.
Yes, ma'am.
Along with Prabin.
Yes.
Your name, sir?
Chandrasekhar Padi. Yes.
You are not S. Padi.
No.
Achha. Mr. Samir Mishra, along with senior advocate, along with Mr. Prabin Das and Chandrasekhar Padi for the petitioner, for the appellant.
And we have taken consent from Prabin Das.
अच्छा प्रवीण दास ठीक है ताले प्रवीण दास ने आर्टिकल करते समीर कुमार मिश्रा along with
J Pradhan
party चंद्रशेखर पाड़ी ठीक है मिस्टर प्रेम कुमार महांती additional standing counsel for OP number R1 Mr. along with senior Mr. Mishra
No, only me.
Mr. Tanmay Mishra for direct counsel OP2 R2 then Lekhibe office note indicates that the postal article has been delivered as is evident from the postal tracking report wherein notices were issued to R3 to 5, 3 to 6 3 to 5 upon actually 6 ଆପଣଙ୍କର ପାୱାର ନାହିଁ MS ତାପରେ 6 को मैं appearance लिखନ୍ତୁ Mr. Amit Prasad Bose along with
ऋतुपर्णा
चैटर्जी ଆପଣ ନାହିଁ to पावर ऋतुपर्णा चैटर्जी appearance सरला ସେ କଣ ଲେଖିଲେ office note indicates so and so Indicates Mr. Atiki delivered exactly correct. Yes, containing the notices issued to so and so, so and so. Full stop. Awaiting appearance of respondents 3, 4, and 5. The matter shall be listed for orders in the week commencing.
Those are.
You have any connection with them? Strategy.
Wow.
Can you help they appearing?
5.
Ah.
I have to take instruction.
Pacharantu. The court has nothing to do, but the thing is that this will be kept pending, that this appeal will be kept pending. Of course, it is a fresh matter, but still there. Yes, next.
Obliged.
Mr. Misra, just think about interim order, interim order dated so and so shall continue till the next. Execution file is. Interim order कौन थिला? Mediation नहीं परियो किसी टाइप of.
We have to take.
You take instruction. The Tanmay also please.
Not.
If mediation can work out, it is better.
Because here it's
and you can go for it can be sent to DLSA for the local wherever they are residing. It can work possibly.
I'll take it.
Yes.
Obliged.
Interim order dated
14/5/26.
Okay. Yes. Interim order, but it's a permanent order actually. Without leave money, it is goes for all the time. Interim order dated so and so shall continue till the next date of year. 14/5/2026 shall continue till next date of. Next.
Item 30.
Item 30. So I'm supposed to file the wakalatnama. Because I've received the wakalatnama in the meantime.
So Ashok, you are there. So Ashok Kumar Mahapatra for the petitioner, opposite party black. Mr. L.K. Maharana Learned Counsel submits that he has received wakalatnama. He shall file the same
today
in registry today. The wakalatnama shall be taken on record, scanned copy be updated. Name of Mr. Maharana Learned Counsel and Learned Associates shall be indicated in the case brief as well as the cost list from the next listing. Any instruction, Mr. Maharana?
I was just discussing, Malats, it can be sent to local DLSS for mediation. It can be resolved.
Has to work out at your level. So you take a short date. The matter shall be listed for orders in the week commencing. Aji kete? 14. Next week asibo?
Again.
The week commencing 27. Liberty to mention. Suppose you arrive at a solution by tomorrow, please mention.
I will.
And then give example, not just by tomorrow. Yes, next.
31.
J. Swine for the petitioner, Mr. Prafulla Kumar Mahapatra for the opposite party.
My lord, on the last occasion, notice was issued on the limitation bit, sir.
Okay. Limitation objection debe. The Learned Counsel for the petition opposite party submits that he shall file objection to the application for condonation of delay in filing the appeal. How much time?
2 weeks time.
For which he seeks for the 2 weeks time. Stop. Accordingly, the matter shall be listed for orders in the week commencing. 10/8/2024. Copy of the objection, if any, shall be filed after serving copy thereof of the Learned Counsel for the petitioner. For the petitioner appeal hochi na kon hochi? GUAP re kon lekha hochi? It is appeal. Upon lekha hochi kon? See, petitioner opposite party lecture. But it is appeal. Petitioner opposite party. Yes, next.
32.
Notice was earlier issued in this case and the opposite party has already appeared.
So
and there is a condonation. Power has already been filed and there is a delay.
Ippudu PB Bahali. For the petitioner, though Learned Counsel have entered appearance pursuant to instance of notice No one is present on behalf of the opposite party when the matter is called. The matter shall be listed for orders in the week commencing.
3-8.
3-8 है Mr. Bhali?
आगे
3-8. Next.
33.
Since we have already reaching the end, so rest of the matters can be, if you want, it can be specifically adjourned to a date or it will be distributed by the court master. 33 कौन Mr. Beuria?
Minus. Recommencing 10th of August.
କରନ୍ତୁ 10-8 କହୁଛୁ 34 to 30-40
मतलब 36 ଟା next week ହିଁ ଆସୁ 34 ବୋଲେ
ନାଇଁ 36 ଟା ଆପଣ ନେକ୍ସଟ ୱିକ୍ ନ ହେଇ ପାରେ କେବେ ଅଲି ହେଇ ପାରିବ କରନ୍ତୁ 36
3-8.
3-8 ହଉ ଆଜ୍ଞା 3-8 ରେ ସେ ରଖିଛନ୍ତି 113 ଟା ସେଥିପାଇଁ ସେ କହିଛନ୍ତି ନେକ୍ସଟ ୱିକ୍ ରେ ରଖିଛନ୍ତି 20-7 ରେ 144 27-7 ରେ 138 27 ରଖନ୍ତୁ ଆପଣ ଖୁସି 27 ୱିକ୍ ରେ ରଖନ୍ତୁ
34 one month time I can give him
ଆଜ୍ଞା
ଗୋଟେ ମାସ ସମୟ
ତାହେଲେ ସେଟା ଆଗକୁ ଯାଇପାରିବ ଅଗଷ୍ଟ 17-8 ନା କେତେ କରୁଛନ୍ତି
3-8.
17-8 କରିଦିଅନ୍ତୁ ଆଜି ହଉଛି 17 ନା 14 17
oblige
ମିଷ୍ଟର ମହାରଣା 35
49 loss
35 ମିଷ୍ଟର ମହାରଣା ପଳେଇଲେ ଏଠି ଥିଲେ ଏବେ ଠିକ ଅଛି ଆପଣ କେତେ କହୁଥିଲେ
48 short.
ଆପଣଙ୍କ
49
ନାଇଁ ଯାଇନି ସେ ଯାଏ 40 ମତେ କୁହନ୍ତୁ ନହେଲେ I will go to next page then 41 to 49 49 madam 48 yes
Short adjournment.
short in the sense it has to be adjusted
Yes, madam.
48 କରନ୍ତୁ
42 minor.
10-8.
10-8 week
49 your lordship week commencing 10th August
says 10-8
Your Lordship, item number
49
41,
42
49
49 ହେଲା ସରି ଆପଣ ଜାଣିପାରିଲେ 49 10-8
yes
42
minor 42.
ତ ମହାନ୍ତି
Next one.
42 ଟା କରନ୍ତୁ
Your Lordship, item 41.
Interior order to continue.
ଗୋଟେ confusion
Interior order to continue.
କୋଉଥିରେ
42.
42 ରେ adjournment ଥିଲା ନା stay ଥିଲା
Adjournment.
Mr. T.K. Mohanty, you are Mr. T.K. Mohanty.
Minor.
T.K. Mohanty for the petitioner. Opposite party blank 42.
I am for the opposite party in 42
So Bag. So Manas M.R. Bag for the opposite party. The matter is listed for hearing under the heading for admission. Stop paucity of time intervenes. The interim order date ଟା ମନେ ଅଛି
Interim order is passed 22/5/2024.
The matter is mentioned by the learned counsel for the petitioner at the end of the day's proceeding in presence of the learned counsel for the opposite party. Stop. The matter shall be listed in presence of the learned counsel for the opposite party and praise for extension of the interim order. Stop. The interim order dated 22/5/26 is reiterated. Para sister repeat कर देवे. Date केबे आपण कहले?
We commencing 10-8.
We commencing the shall be adjourned beyond 17-8 is state for admission in the week commencing 10-8. Yes.
Your Lordship, item 41.
Yes, please.
Kindly grant a specific date.
Cannot be. What about yesterday's matter? What about the yesterday's about 50-60 matters? What about them? Have you realized how it helps? It helps much better. If I fix a specific date, suppose like yesterday the batch could not function. Can the registry list the matter?
No,
Cannot. Court master cannot. Nobody can. When there is a judicial order, it cannot be listed. It can be adjusted now. It has now increased to 55.
Yes, Your Lordship.
So it cannot be adjusted unless you make it a week. There is a purpose. There is a method in doing the things. Or if you say it is madness, let it be, but method in madness. ଆପଣ ଯେତେବେଳେ ଜିନିଷଟାକୁ flexible କରିବେନି, it becomes fragile.
Yes, Your Lordship.
It cannot work. ଆପଣଙ୍କର ସ୍ପେସିଫିକ କୋଉ ଡେଟ୍ ରେ ହଉଛି ବିକଜ ୟୁ ଆର ଲୋକାଲ ବାର ଆପଣଙ୍କ ୱିକଲି ଲିଷ୍ଟ ଭଳିଆ ଲିଷ୍ଟ ହଉଛି ଆପଣ ସବୁ ଜାଣିଛନ୍ତି କୋଉ ଦିନ ଆସିବ ଆଉଟଷ୍ଟେସନ କାଉନସିଲ ଯେ ଟ୍ରାଭେଲ କରିବେ ହଁ ତାଙ୍କ ପାଇଁ ଆପଣ ସ୍ପେସିଫିକ ଡେଟ୍ କହିବେ and gradually weekly list has been eliminated from High Court. Usually there was a weekly list and a supplementary list. 41 କେବେ ଚାହୁଁଛନ୍ତି ଆପଣ ସବଜେକ୍ଟ କୋଉ ଡେଟ୍ ରେ ଆପଣ ଚାହୁଁଛନ୍ତି next week ରେ ହେଇପାରିବ next week is 144 144 ଟା ଅଛି
We commencing 27.
27 week ରେ ଅଛି 138 if you want it can be add कर दियो 27 7 and if you see other high courts they have a method in not listing matters so proximately because then what would happen because you are mentioning only your matter will be listed there are other matters. Is it necessary that Mr. Samal is not there, so it should not be listed? So, more the number of cases should be accommodated in the list. Yes, 42 to 49.
Lordship, item 38 on behalf of Mr. Vijay Kumar Das, today file and reasoned.
38 date note. 38 date कर दियो.
Who comes in 10
week. Yes, madam. ताले आपन राउडी मैटर अछि मिस्टर महांती
No, ma'am.
Interim order.
नहीं 38 इंटरव्यू ऑर्डर कोन थिला सेटा को देखु तू स्टे थिला ना कोन सेटु आपन त आसीबे सीधा देखिबे सेठी आपन पे दिया अछि सेटा तापर सीधा कहिबे डेवलप मेथड कोन इंटरव्यू ऑर्डर थिला ते थिला ना कोन एडजमेंट थिला
Stay थिला Lordship.
ते रिमेन्स अनटच्ड rather order pass নহলে आपन पे भलो कोचोनी when there is a stay order it continues because the matter could not reach. Yes. Actually, आपण distribute कर दियो.
Your Lordship,
Item 52, my lord.
52, yes, sir.
My lord, here there is a stay order operating against us. My lords,
You suggested date, Mr.
any time at 2 o'clock, whatever is convenient. I only want the matter to be heard because a truck association, my lords, the entire body was superseded by the ADM because they were not giving any statistics or my lords audited reports.
So 3rd August week is 113 ta achi. Should we add that or the next is
your lordship's convenience apana jouthre karibe khali mo
8 tale 10 8 week diyo 70 ta added to that. Yes.
Your Lordship,
can it be at 2 o'clock, my lord? Or subject, I'm not asking for you. If your lordship's convenience it
let us see. Liberty to mention is there. Let us see.
Lordship, item number 55.
Obliged.
On last occasion, the court directed to file the counter. Your Lordship, we are ready with the counter.
You serve it and file it. No difficulty.
Your Lordship.
You want a date or let it be adjusted? Any
date.
Upon so you serve it and file the counter.
Yeah.
Okay.
Again,
Okay, Subilan. 52 टा मिस्टर तरुण को 10 8 है ना 10 8 विक्री दियो जोतरे कम अछि 70 टा अछि यस 8 करो यस